Hey guys, what's up? Welcome to Lawsplaining the Interwebs. I'm your host, Nick Rekieta. I'm a central Minnesota lawyer. My law firm is Rekieta Law. And today we have another treat. But first, I have to do the most unprofessional thing that I can think of and step away from the camera because I'm not fully prepared. I have to close the door. Be right back. Sorry about that. So anyway, let's see. Today we have in our possession something I thought would be, I thought it would be funny, but I didn't think it would be as funny as it is. This is the response. If you're not aware, which I think most of you probably are who are watching this live, but this is a response from Maddox, aka George Azunian, and Jessica Blum through their attorney Kevin Landau, and this is the response to Dax Herrera, Greg Bozer, and Foundation Digital. Elijah Watson comes in with an early super chat. Thanks for the content, buddy. You're welcome. It is my pleasure. And this is a great opportunity for me to talk about how this can work really well for all of us. So I am attempting to follow the chat, but I can't watch it the whole time because it's super distracting because you guys are hilarious. So if you tag me, I will attempt to address your comment or answer your question if it's possible for me to do so. If you do a super chat, like Internet Tab just did, thanks, Dog Bites. Yes, if you do a super chat, it will force me to see it, and I will be able to address it right away. I do not in any way want to imply that you must do a super chat to get a question across or anything like that, but I really do appreciate it if you do the super chat, and it helps me see it. Matt Reifler, yes, that's how you tag me right there with an @ Rekieta Law, and it will highlight that in my chat, and I will try to get to it. Windows 95 time estimate is 2 to 3 hours, hopefully less. Arbin Gordon, yes, there is a Discord, and that Discord is it's a Patreon only Discord currently. So for info on that, hop to Patreon. Are traps gay? Probably. Not always, though, right? I don't know. Windows 95, 2 to 3 hours.
Would it be completely distracting for your daughter to come hug you?
No. I have fatherly duties here, guys. So give me just a second. Come here. Give me a hug. Love you. Good night. Hi. Get out of here. Mr. Prescription Lizard, you got traffic court tomorrow for going 95 and a 55. What should I do? Pray they don't show up. Also, hope you didn't say anything. Kevin Flesher, thank you, Nick, for the content and GFY. You too, buddy. Back at ya. Internet Tab, if you have something funny to say, do a super chat. That is a great thing to do. So, I'm going to turn away from the regular chat for a little bit, and let's get... Guys, stop being funny. Seriously. Thanks at Kellensteck. I try to be a good dad. Tabmock99, I want to write a book. I really do. But I don't know what to say yet, because I keep spilling it all onto this screen. So, without further ado, so we have a couple documents, and I'm gonna blitz through what they are real quick as a summary. We've got the response document. This is the memorandum in support of the response, and it also includes a cross motion for discovery, which is, we'll see. Then we have Saddox's affidavit, where he whines a lot And then we finally have this beautiful 61-page exhibit. And 61 pages will not take that long because these, like, just looking at these are not full pages of text, right? I don't want to spoil any of the surprises, but I'm going to attempt to get through all of this. Only if the wife drinks all of your scotch, hot snodge. At Max, don't ever get caught by him. At Mr. Prescription Lizard, if you reschedule, think they won't show up. It really depends. It's kind of hit or miss. There's a lot going on in traffic court that you got to watch out for. They're hard to fight, but some of the stuff you can do is you can demand full discovery. You can demand tests of the equipment. You can do stuff like that. I strongly urge you to talk to a lawyer in your state, especially with that sort of charge, because 40 over might include reckless driving. So you want to be careful with that. Talk to a lawyer in your state. There are ways to fight it. Bill Kinirons. I don't have anything funny to say, but I wanted to make sure everyone knew it. Yes, they all do now. So without further delay, let's jump into this document. And right away, Landau comes in hitting hard with having the improper use of an apostrophe on, he does it up here, actually. In the caption, again, is improper apostrophe. And then he does it down here. He has an improper apostrophe as well. Max, you got to talk to me privately on that one, buddy. So plaintiff's cross motion to dismiss and for discovery on personal jurisdiction pursuant to CPLR 3211D and memorandum of law in opposition to defendants Herrera, Foundation Digital, and Bozer. Motion to dismiss. And Bozer, there's an opportunity to use an apostrophe and he doesn't. Bozer's motion to dismiss pursuant to CPLR 3211A7 and 8. Landau Group PC. Attorneys for plaintiffs apostrophe again. Guys, it's the caption page, and we have 3 grotesque apostrophe errors. Let's give one shout out to the moderator, who has done a fantastic job so far, and I assume will do a fantastic job tonight as well, keeping me on track and keeping unnecessary distractions out of the chat. If you can hear that, that's me popping this lovely bottle of White Mackay. I was corrected on the pronunciation. White Mackay. I'm not very Scottish. But this was sent to me by a fan of the Dick Show and a fan of me. I really appreciate it. He's a great guy. And we had a very good discussion about it. Kevin Cartilage, how much Skrilla is needed for you to be an in-studio guest on TDS? It's less about the Skrilla and more about getting to LA and getting into that bunker, which is fortified. We'll see. That's up to Mr. Masterson, and I think that may have to be something that waits till after this whole thing blows over. But he'd have to talk to his lawyers about that. My accent is racist. Oh, the Scottish accent. Yes, I will stop. I apologize. So here we have the table of contents. One more sort of ground rule about this. There probably will be some coarse language. If that is bothering to you, it will probably not come from me unless I'm reading something off of this document. I try and keep it down when I can. But, some of the stuff in here, cuck is right there. And cuck is very offensive to some people. Yes, we're going for the Under Armour sponsorship as well. Under Armour, if you're interested, I own a lot of your clothing and shoes, so please contact me. All right. So, we're going to skip this. Not really interesting. Table of authorities. Look at all these authorities. And the best part is you can pretty much wager that at least half of them are used incorrectly and the other half are irrelevant. So let's move on to the introduction. Plaintiff's apostrophe, George Azunian, hereinafter Azunian. Why isn't it Maddox? And Jessica Blum, collectively plaintiffs. He left out an apostrophe from this collectively, I think, based on his standards, not on what should be done. Through their attorneys, the Landau Group PC respectfully submit this cross motion pursuant to CPLR 3211D in their opposition to defendants apostrophe Dax Herrera, professionally known as Dick Masterson, hereafter Herrera, Greg Bozer, and Foundation Digital, collectively defendants motion to dismiss pursuant to CPLR 3211A7 and 8. I can't even pronounce that. Arzikidu. Liked your Demore videos. It is really bad in the Bay Area tech industry. I'm glad to see more normal non-Californians hearing how bad it is. Yeah, man, those documents are crazy, and hopefully we'll get to see Google's response before too terribly long, because I'm really interested to see what their factual analysis is. So back to this document. Statement of applicable facts. Defendant Dax Herrera's... Guys. Dax Herrera apostrophe S is conducting business in New York. Defendant Dax Herrera is an individual residing in and around Los Angeles, California, conducting business in New York. Citation needed, right? Defendant Herrera, with the other defendants apostrophe herein, have used the Dick Masterson persona. By the way, I want to know who other than Dick is using the Dick Masterson persona. How are they using them? Do they have permission from Dick? How does that even work? Like, are there multiple Dick Mastersons? Mr. Herrera, please let us know that you're not the only one. Across social media and the internet, Twitter, Facebook, U-Space-Tube, capital I-Tunes, to create a lucrative business based on creating violent and hateful content, or a science and rage-based podcast, right in the description, directed at and against plaintiffs' apostrophe, thereby encouraging and inciting their listeners and followers to threaten, stalk, harass, defame, and interfere with all aspects of plaintiffs' apostrophe personal and professional lives. That's an actual appropriate apostrophe. Good job, buddy. You're like 1 for 12 already. Defendant Dax Herrera is a published author operating and conducting business in New York, somehow, under the pen name Dick Masterson, with a publishing contract with Simon & Schuster located at 1230 Avenue of the Americas, New York, 10020. That's from the Azunian affidavit. Dario Cambron, will Landau sue for laughing at him? Will Landau S apostrophe ooh for laughing at him, comma, 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 comma. Yes, I think so. I hope so, right? Huge Cock says, in good form tonight, you beautiful son of a bitch. Thank you, buddy. It's because this is great. So let's get to it. So the character created by Herrera, Dick Masterson, which his book and Patreon podcast, Why Men Are Smarter Than Women and The Dick Show, respectively. I mean, I'm not Dick's lawyer, but I assume Dick's lawyers will simply say, Dick never wrote a book called Why Men Are Smarter Than Women. I don't even know if that book exists. If it does, what is Landau reading, by the way? That's a pretty offensive title. Doesn't seem like it's within George's wheelhouse there. Kevin Flesher, correctly used apostrophes are for cucks. Yes. Respectively. So Why Men Are Smarter Than Women in the Dick Show, respectively, are based on, and which he uses to generate his revenue on Patreon, was created in New York City. Spicy Tony. Count Dankula did nothing wrong. I agree. Absolutely nothing. Figured out why it's in New York. Maddox is a New York Times bestseller. This is the connection he clings to. Yeah, Internet Tab. I think that may be. He might, knowing Maddox, he might not know that other states exist than New York. So we'll see. So they're alleging here that Dick, the Dick Masterson pseudonym, persona, business entity, whatever you want to call it, the trademark, was created in New York City, which seems a little strong because I'm pretty sure that Dick created the Dick Masterson website, Men Are Better Than Women, prior to releasing his book. Why are men smarter than women? I don't know. I don't know why. I don't know if that's even true. I know there's a big argument about it, but that's a good question. Vladimir, no. Like, this case is 1 in a million. It's so funny and so bad. So anyway, they're alleging that the Dick Masterson persona was created in New York, which I think is a big stretch. And the copyright of the name is owned, comma, by New York publisher Simon & Schuster, located at 1230 Avenue of the Americas, New York, New York. Which, like, that's the funniest thing. Why would they possibly think that that is true? Maybe, Andrew. I don't remember. Yes, you can sue Maddox for the Maddox, not Maddox, Maddox for the Maddox Ponzi scheme, probably. If he breached his contract that's implied by the purchase, which would be interesting, by the way, to see if there is a class action there. But then you'd have to prove that more than himself bought them. Further, Herrera operates under the name Dick Masterson, and the copyright of his book is in Dick Masterson's names, not Dax Herrera's, with Simon & Schuster at 1230 Avenue of the Americas. Now, guys, I want to take a very, very brief pause to go into this exhibit section, because here is what they're basing this off of, and this is interesting to me. So this is the copyright, the short form printable copyright from the U.S. Copyright Office. And if you notice, the copyright claimant is Dick Masterson, transfer by contractual agreement. So the copyright claimant is Dick Masterson, the pseudonym Dick Masterson. And it is transferred by contractual agreement. What is left off of here is that there is an address for Simon & Schuster that follows for all inquiries. Okay. Adam D, make sure you restate the comments you respond to, because others won't see these later. That's a very good idea. So they're stating that Simon & Schuster owns the Dick Masterson copyright. But if you look down here, the authorship on the application is Dick Masterson, author of a pseudonymous work, okay? So, penned under a pseudonym. Let's go. I did this great little thing where I went to the copyright help section from copyright.gov, and I found this interesting thing. Can an organization be the author of a pseudonymous work? An organization cannot be the author of a pseudonymous work. They literally cannot copyright the book as Dick Masterson if it's Simon & Schuster. They have to copyright it as Simon & Schuster. Hello. Like, you have failed the most basic elements of this thing again. And again. If no one buys into your scam, is it still illegal? No, actually, most of the time, probably not, because you have to have damages. But, thanks, IT Weeb. But seriously, like, an organization cannot have produced this copyright thing. This must have been done by an individual. So it can't be Simon & Schuster. In theory, I guess someone else could own the Dick Masterson mark or pseudonym, but I highly, highly doubt it. So let's just pour one out for Landau's legal research. All right. Now that that's cleared up. Further, the authorship on application of the book Men Are Better Than Women, which they at least got right here. Registered with the United States Copyright Office is Dick Masterson at 1230 Avenue of the Americas. Yes, so all inquiries as to the copyright can be directed to Simon & Schuster, at least in 2008 when they published the book. That does not mean that Simon & Schuster is the owner of the copyright or is the owner of the Dick Masterson pseudonym. Good luck. Hat Buckles, you normally don't pour one out into your mouth. Well, that's a waste of some good scotch. So I'm gonna pour one out into my own mouth. You guys can pour out whatever you have onto the floor if you want. That's your prerogative. Mine will not be wasted. Further, the majority, if not all, communications and statements made about plaintiffs on Herrera's podcast are in the name of Dick Masterson, not Dax Herrera. Yeah, it's a persona. It's a pseudonym. It's a stage name. It's a pen name. This is not new law. In fact, the show is called Dick Masterson is Creating the Dick Show. I think the show is called The Dick Show, and his Patreon page is worded Dick Masterson is Creating the Dick Show, which is just kind of how Patreon does it. Nicholas Melchiori, if you get ulcers from too much scotch, can you sue Mr. Dogbite for medical expenses? I hope so. I hope so. Likewise, Dick Masterson has his own website for his book. The book is currently being sold on this website and is linked to his Patreon page where the book is also sold, in addition to other merchandise. You don't need a comma there. Further, this book can currently be bought on Simon & Schuster's website out of New York. Shocking that you can buy a book from the author and the publisher. It's amazing how that happens. If anyone bought Maddox's book, he would probably know that this was the case. Moreover, plaintiff Uzunian annexed relevant pages from his own publishing contract, which he believes contains the same or very similar provisions as Herrera/Masterson's agreement, which is a bold statement because Maddox is terrible at business and Dick seems to be at least competent. So I think to state that that someone who's routinely hoodwinked would have the same provisions as someone who makes competent business deals might not be the same. Who knows? Maybe they are. We'll see. These provisions state that jurisdiction is hereby vested in the federal and state courts sitting in New York County, New York, and the applicable law for this agreement states that it shall be governed by the laws in the state of New York. Let's, again, I'm gonna pop over to this guy. So here's their copyright page, which, notice, the copyright on the Simon Spotlight Entertainment is copyright Dick Masterson. Simon & Schuster, again, would have to copyright it as Simon & Schuster, because to copyright it as you... So here's another little piece of pseudonymous work. You can't copyright it and include both your real legal name and your pseudonym in the work. So if it was Simon & Schuster and they own this name and were copywriting it as a pseudonym and they put Simon & Schuster in there, not okay. You can't do that. So there's another one. Another basic fact wrong. But the thing I want to get to is this. This is the contract of... you cannot buy Maddox's book on his website. Why not? That's a terrible business decision. Okay, so, or maybe it's a good one, because maybe anyone who goes to his website would realize that the book might not be worth buying. So here's what they're going for here. Jurisdiction. This is the jurisdiction section that they're citing. Let's go through it real quick and talk about how incorrect they are. Exclusive jurisdiction for the determination of any dispute solely between or among parties to this agreement. And what was that? What was that? They state that jurisdiction is hereby vested in the federal and state courts sitting in New York County. Notice they left out, and by the way, he left off his ellipses that are kind of required for a quote that is taken without the entirety of the statement. The exclusive jurisdiction for the determination of any dispute solely between or among parties to this agreement is hereby vested in the federal and state courts sitting in New York. That does not mean that jurisdiction for anything related to this work rests in New York, only for a dispute between Dick Masterson and Simon & Schuster. Windows 95, reminder, Valentine's Day is my day and celebrating it is cultural appropriation. Legit, though, it is my actual half birthday. ILY, heart, Amelie Valentine. Love you too, buddy. Half birthdays are awesome, by the way. I love half birthdays. But yeah, so the jurisdiction to New York, the automatic jurisdiction, is a contractual agreement between Dick and Simon & Schuster. Without a dispute, neither of them have actually availed themselves of New York, and this is not a surefire avenue to jurisdiction that Landau hopes it is. Because it's related specifically between these two parties in the event of a dispute. You could maybe say it is a contact, but is it a sufficient business contact? That's a hard thing to say. Thanks, Dario Cambron. There's no note attached, so I don't know. So applicable law is the next section. This agreement and its interpretation shall be governed by the laws of the state of New York, applicable to agreements made entirely to be performed therein. Fun fact, just because something is interpreted and governed by the laws of a state does not necessarily mean that the venue of that state is the proper venue. It just means that whatever venue you choose has to apply New York law to the particular dispute in the contractual relationship. Adam D, I'm getting to this. He says, no, it's not between Dick and Simon & Schuster. It's between Maddox and his publisher that he's guessing is the same as Dick's. How ridiculous is that? Maddox's publisher, I believe, is also Simon & Schuster. But the interesting thing about it is, so if Maddox is asserting that Simon & Schuster own the Dick Masterson brand through contract, should we infer that Simon & Schuster owns the Maddox brand through contract? Like, if that's how he thinks it works, it'd be really funny. Kevin Flesher, I'm typing this so Nick will read the word boner. Yes. Okay, so anyway, the choice of law provisions in the contract are not an automatic route to jurisdiction. Let's be fair, they are evidence, potentially, that Dick is availing himself of New York jurisdiction 10 years ago. The question is, what is the term of his contract? Does it expire? Is there a limit on time? And then 2, is that one connection sufficient? If it exists, is it sufficient to tie him to New York jurisdiction in the event that there is no dispute between him and the publisher? That's a tough question, and that'll be fact specific for the court. But I don't think it'll be fact specific for the court, because if you'll notice, this is not something we've seen prior to this, and motion responses are not the place to raise new factual evidence. You had a chance to do that. It was in the complaint. If you thought that his jurisdiction to New York, or his tie to New York jurisdiction, was valid through his contract, you needed to assert that fact in the complaint. You can't do it now. You lost your opportunity. The motion will only be heard on evidence in the complaint. Adding new evidence now, not going to work out. Dario Cambrion, I was going to a titty bar, but rather see this. Well, thanks, man. That means the world to me. Let's see. So the provisions state the jurisdiction is hereby vested in the federal and state courts sitting in New York County, New York. The applicable law for this agreement states that it shall be governed by the laws of the state of New York. Good job failing on that one. Moreover, Herrera's editor with Simon & Schuster is Mr. Jeremy Ruby Strauss, who is Uzunian's editor. Oh, poor guy. Who Herrera contacted by email immediately after being served with the lawsuit in this matter on or about November 14th, 2017. Mr. Uzunian was CC'd to this communication. Should we see this real quick? Because this is funny. Sorry that it's sideways. I don't know why you would include a sideways document. But, George. So this is from Dick Masterson to Jeremy Ruby Strauss, George Uzunian, and Michael Malice. George, this is the funniest thing you've ever written. Congrats. Better luck on the next book. Burn court is adjourned. Mr. Uzunian was not CC'd to this communication. He was included in the it's always louder in the left channel. Let me see real quick if I can oh man, I can't change it to mono right now. Maybe if I turn it this way. Does this help? I think this should balance it out a little bit. I just rotated my mic a bit. I'll work on getting it balanced out next time. So yeah, George was not CC'd in that communication. He was just in the line. Yeah, Max, come to my house and help out with audio. Further, Herrera solicits money and operates under the Dick Masterson name on his Patreon page for his podcast to hundreds of New York residents. Citation needed. How do you know he goes to any New York residents, much less hundreds of them, which pay him substantial sums of money on a recurring monthly basis and is currently generating over $22,000 a month from over 3,000 patrons. Let's see. Actions taken by Herrera subsequent to the instant lawsuit being filed. Spicy Tony, to be fair, you need to have a very high IQ to get Maddox. I think that's absolutely true. Moreover, subsequent to the instant lawsuit being filed and served on Herrera, and after multiple stipulations between the parties to extend the time to answer, you asked for those, and the instant motion to dismiss being filed, he has continued his harassment campaigns against plaintiffs and continues to target them and post defamatory, racist, misogynistic, and other hateful content throughout social media and on his podcast, Uzunian Affidavit at 14. Actually, I don't know of a single defamatory, racist, misogynistic, or other hateful thing that Dick Masterson has posted on social media or his podcast. And even if he did, the only one that would potentially be actionable would be defamatory. The only one potentially actionable would be defamatory, and that would be if you could sustain that it was in fact defamatory. But you haven't done that. So all of your requests to stop are pointless at this point without a court order. If you got an injunction from the court stating that Dick could no longer say things about Maddox, then maybe you'd have grounds, but you don't. You're adding new evidence here. This whole section has to basically be ignored in the motion consideration. Is it instant lawsuit like instant noodles? Yes. I'm pretty sure he just poured some ink and water on top of a stack of paper, and this is what came out, because that's the only thing that can explain the incoherent nature of these documents. So invasion of privacy, false advertising, defamation, and other tortious acts by Herrera and Coquinos. Defendant Herrera participated with co-defendant Asterios Coquinos in the podcast entitled The Dick Show. He participated, I guess he hosted it, whose reach spans across social media and the internet. Patreon, Twitter, Facebook, Uspace, Tube, i-tunes, Bandcamp. The Dick Show prides itself on the creation of hateful content. Does it? Like, you could show this if there was actual pride in hateful content if you just pointed to a statement saying we pride ourselves on hateful content. Yes, Maxwell Silver, that's what Matt Reifler told me, that pee is stored in the balls. And violent suggestions. Where are those? Primarily devoted to the destruction of the plaintiff's reputation, privacy, safety, and general consideration of basic rights we all enjoy, such as fundamental decency and privacy. There is no right to fundamental decency, and the privacy right does not come from privacy from other people. It comes from government, and it's also kind of a created right, which is a weird hybridization between the 4th and 9th Amendments. Thanks, Roe versus Wade, for fabricating a fundamental right. But, like, you can't even come close to saying that decency and privacy are fundamental rights to anybody. Dominic Peluso, Nick is a beautiful African-American woman. Not today. Not today, I'm not. Said defendants routinely encourage their listeners and followers to threaten, stalk, harass, defame, and interfere with all aspects of the plaintiff's personal and professional lives, rehashing the complaint. Plaintiff Blum was, and as of the date of this motions, good plurality agreement there, continues to be a target for said defendants, often being a punchline. It's better than being punched by her boyfriend. I don't know if he would do that. That seems a bit out there for Maddox. Would she punch him? I don't know. Often being a punchline or just a victim of the show's constant vitriol, simply because she is a beautiful African-American woman. Like, where's this coming from? I mean, like, you can find her beautiful African-American woman, but what place does it have in a court document? And model in a relationship with Mr. Ozunian. See the complaint again, and then the attached Exhibit 7 and 8. Okay, and those are just exhibits from the complaint. Numerous examples of defendant Herrera's targeted crusades against plaintiff's apostrophe exist, replete with defendant's defamation, fraud, and encouragement. In paragraph 35, Windows 95, Rafael Barba should be disbarred. Such poor ethics. In paragraph 35, plaintiffs allege nearly 50 defamatory statements personally made by Herrera against plaintiff Ozunian or plaintiff Blum. Next to is Exhibit 9. That'll be fun. Except that that's from, I think, let's see, real quick. So Exhibit 9. No, see, this is the same thing from the complaint. He just forgot to cite his own complaint again. These, I went through those. Those aren't real. Because they don't amount to anything illegal or actionable or even questionable. For instance, one of plaintiff's major sponsors on his website was from a company called Harry's. Harry's sponsored 2 shows. 2! They could not have been providing you the amount of money you lied to the court about them providing. They just, There's no way they provided $7,800 a month for sponsorship on 2 of your shows, which no one listens to. Which is a New York-based company that defends Kokonos and Herrera in coordination with the latter's fans. Spammed Harry's social media sites. What is spamming? You should probably define that for the judge. With defamatory and outrageous accusations against Uzunian, such as calling him a liar who supported rape. Is that a defamatory accusation, or is that an opinion based on your book with the chapter copying a feel? I don't think they, and it's a colloquial use of rape, obviously not a legal use of rape, which is common to people like Maddox, who will colloquially use rape to talk about non-penetrative sexual assault. But, that's these aren't lawyers talking. So they can use colloquial words. Colloquial. Plaintiff Uzunian's claim is based on the harassment campaign to destroy his relationship with Harry's by encouraging their fans to troll through plaintiff's network, looking for clips, take out of context, then in coordination, like he's just copying and pasting from his complaint here. Then in coordination with defendant's fans, spamming Harry's social media sites with defamatory and outrageous accusations against plaintiff Uzunian, including in social media posts that he was a liar who supported rape. You just said this exact same thing. Harry's terminated its agreement with plaintiff on January 9th, 2017. Maybe you shouldn't be a liar who supports rape. Defendants apostrophe have also created Wikia and Encyclopedia Dramatica pages. Proof necessary. You can't just state that someone does something. Provide the evidence. Elijah Watson, the response to this should just be this document with a giant citation needed stamp. No fancy lawyer, man, but I'm fairly sure that's a valid response. It might actually be. Which contain knowingly false allegations, including the existence of Miss Blum having sexually transmitted diseases, STDs, such as, quote, herpes, mental problems, apparently an STD. Because of the poor punctuation, we don't know if he's asserting that mental problems are in addition to STDs, such as herpes, or if STDs includes herpes, mental problems, homophobic and racist slurs. So homophobic and racist slurs are STDs. And a demeaning and intentionally inaccurate story of plaintiff's apostrophe lives. Oh, that's the right apostrophe. Good job. For public consumption. So what? Brett Andreasen. Mr. Burgers and Alts are the serial harassers. Yes. We know. Well, we don't know. I believe it's been shown relatively well, I think on Reddit, that Mr. Burgers is behind pretty much all of it, if I remember right. And Maddox was a huge fan of Mr. Burgers when he first said get raped on that first live show from The Biggest Problem. Thought that was hilarious. Anyway, yes, they posted an intentionally inaccurate story of plaintiffs' lives for public consumption. Did Dick and Asterios do that? Or did some fan or someone else do that? Let's see. With photographs and false advertising without plaintiff's permission or consent. Defendants have also had contests to stalk and harass plaintiff's apostrophe, period. For instance, defendants apostrophe held a billboard contest. The billboard never got made. Internet Tab says projection. Yes, projection. Because of course the grand irony of all of this is that Maddox did almost all of these things himself or through his associates and accomplices. The difference is that Dick didn't sue him. So, held a billboard contest wherein defendant Herrera asked his fans to send in designs of billboards to place near plaintiff's apostrophe. Oh, that's again a correct apostrophe. You got to stop using the correct ones here, Landau. Now we've gone into bizarro apostrophe world. You should only use them incorrectly. Placed near plaintiff's house to harass and stalk him. Defendants have incited the practice of doxing. The practice of doxing. Like the practice of yoga or the practice of law or medicine is the practice of doxing, which is the coordinated effort to incentivize their followers to uncover private information unique to the plaintiffs, their family, and/or business associates. Here's the real question. Does Dick, who knows Maddox personally, need to incite anyone to dig up this information? In theory, if Dick were doxing Maddox, he would just do it because he knows him. In fact, he was talking about putting up a billboard by the house of Maddox because he presumably knows where his house is, because he spent 2 years recording in that house. And to my knowledge, Dick has not ever doxed Maddox's address or any other personal information about him. So again, citation needed. Totally isn't my billboard and lawsuit. Please no sue from Windows 95. Defendants have featured the doxing technique. What is the doxing technique? Can I get a doctor to tell me what the doxing technique is, please? Andrew Myers, plaintiff has a goddamn restraining order against her for harassment. Yes, that's a good point. Jessica Irene Blum has a restraining order for actually engaging in this type of harassment against 80s girl. Hat Buckles, can the Jem Henson estate sue Mr. Orzo Onion for stealing Kermit's voice and Miss Piggy's general behavior? That's a good question. I'm not sure if that would fall under fair use or not, as parody. It would really depend on the context of Maddox's use of it. So they featured the doxing technique against plaintiffs routinely, space, for the sole purposes of harassment and or blackmail. Blackmail! Yeah, Max, I can explain prima facie affidavits, but I don't know if now's the time. Prima facie is just a Latin term that means on its face. Further, defendants apostrophe Herrera and Kokonos have purchased multiple advertising campaigns on Reddit and Facebook targeting plaintiff's apostrophe and plaintiff Ozunian's followers directly. So they... Oh, that's actually that's a sneak... Wait. Actually, I don't know. I don't know if that's a sneaky correct apostrophe because you're saying plaintiffs and plaintiff Ozunian's followers directly, so implying that Jessica Blum's followers are included, or if they're targeting the plaintiffs and the plaintiff's followers directly, so that they unsubscribe from his podcast. Again, Landau, the reason I'm picking on you for this just atrocity of punctuation and usage is because people lose lawsuits for bad punctuation and usage. Whew. If I was your boss, I would fire you so fast for stuff like this. Because you'd seriously be risking malpractice claims. Defendant Herrera is also using a caricature of plaintiff. Caricatures, by the way, likely fall under parody and are a recognized exception. But, you know, who cares? Caricature of plaintiff as the devil in his posters and advertisements. To promote a live show he purportedly gave on October 13th, 2017, whereby he sold tickets for $20. You're going to have to probably up that ticket price there, Dick, because they're selling out, right? Don't up the ticket price. I did not say that. Defendant Asterios Kokonos, defendant or Kokonos, is a senior copywriter at Weber Shandwick, and we do not know why his actions are at all relevant in a motion to dismiss for failure to state a claim against Dick, Bozer, and Foundation Digital. Let's see. Yeah, senior copywriter at Weber Shandwick, residing in and conducting business in New York, New York. Kokonos has assisted the Dick Show in all aspects of its campaigns, all of them, against plaintiff's apostrophe, and created his own brand and subsidiary business from said campaigns and harassment. Which I wish him all of the luck. Good job, Asterios. You paved the way for the rest of us. Good job, buddy. Kokonos also created false advertising campaigns on Reddit against Mr. Ozunian to fraudulently misrepresent plaintiff's brand called Madcast Fan Statement. I mean, this is all from the complaint still, and I apologize for rehashing the complaint, but I am bound by what the dog bite lawyer does. In other posts from June 4th, 2017, defendant Kokonos continues to boast to his fans about this campaign against plaintiff and states, well, that sounds like it could break a certain platform's terms of service. Like, lying and implying, apostrophe. Yeah, thanks, Dario. And I'm pretty sure that Maddox's actions did break a certain platform's terms of service, but, you know, whatever. It's made George scared and uncomfortable that this could hurt his book release, and that's enough for me. Making someone scared and uncomfortable about a book release is not illegal. It's only illegal to make someone scared and uncomfortable, generally, of an imminent threat of physical harm. that would be like being scared and uncomfortable when that would be legally relevant. But just doing it about a book release? Not really. He should have been scared and uncomfortable about his book release because his book was just a rehash of all of the stuff he wrote years ago. Kind of like this document is a rehash of the complaint. Cuxmas Carols. Bald-headed lies by Santa Cuck. I'm never going to get over that. Windows 95 says, hashtag dick lies, apostrophe. So defendants Herrera and Kokonos. Defendants Herrera and Kokonos made an album using Weber Shandwick's equipment. Well, that is a fantastic claim. Dick, I did not know you flew to New York, used Weber Shandwick's equipment to record an album with Asterios that you don't get any credit for, and lied about it. How are you misrepresent to your fans that you weren't part of Santa Cuck? I think it would have sold way more. Even more copies if people knew that you were in on it too. Uh-oh. The stream is... Hold on. Okay, sorry about that, guys. Had an internet glitch. We should be back live. Guys, am I back? I'm frozen. It's coming. My internet is catching up. Look at all my fun faces. Can you hear me? Okay. Please get yourself a business connection or something. Elijah Watson, I actually, this is faster than my business connection. Believe it or not, we're in rural America here. So, all right. My internet is causing Tortious interference. I think so. Yeah, Google's shutting me down. I've been Sundar struck. Thanks, Andrew. Okay. Let's get back into it because my OBS app says that the stream is stabilized as far as bandwidth. So let me just say that Dick, getting back to this, I cannot believe that you flew to New York, recorded an album with Asterios on Weber Shandwick's equipment, and didn't tell anybody. That's absurd, and I can't believe you lied to your fans in that way. Such album was created by Santa Cuck, Kokonos, and based around his vitriol toward Mr. Ozunian. On February 16th, 2017, Dominic Peluso, the Bogdanovs are shutting it down. Defendant Herrera stated on the Dick Show's official fan forum that Maddox is bragging about his bonus episode, Do Dickheads Want to Win at Something Else? In response to this, a fan proposes certain vile things in pertinent part, which Defendant Kokonos responds to in pertinent part as follows. Asterios, your language here is without decorum, proper decorum here. Oh shit, this is a really effing funny idea. I'm going to do this ASAP. Kokonos then makes a series of related posts to update his fans on the progress of the album, with incentives to encourage its production. So Dick promoted a bit of Asterios. That does not mean that he was part of it or a co-conspirator. On or about March 4th, 2017, Kokonos released his album on iTunes entitled Cuckmas Carols, Bald-Headed Lies by Santa Cuck. Some of the songs and lyrics from said songs are transcribed in full at Exhibit 13 here too, attached here too. And there's a footnote. Another song from the album is entitled See You Next Cuckmas Maddox. On March 7th, 2017, Kokonos appeared on The Dick Show to discuss and promote this album. A video, yes. Why would he have to appear if Dick was a co-creator? Dick could just, discuss and promote it himself. A video of the show is uploaded to YouTube and appears under the name Santa Cuck Cuckmas Carols The Dick Show. Further, on March 18th, 2017, Billboard reported that the album was a number 7 best-selling comedy album in the country. Billboard charting Asterios Kokkinos with Cuckmas carols forever in the annals of Billboard's records. As such, defendant Kokkinos participated, created, and incited many of the campaigns against plaintiff's apostrophe during work hours or after work. None of this is relevant to the dismiss motion from Dick Bozer and Foundation Digital. Not a single thing. But it is funny. From Weber Shandwick's offices located in Manhattan, often using Weber Shandwick's equipment. Again, any sort of proof. Spicy Tony, patreon.com/Asterios. There's an apostrophe at the end, but I don't know if that's supposed to be there. Let's see. Further, as demonstrated by the foregoing. Not really. That's an overstatement on your part, Landau. The breadth and extent of defendants' apostrophe, Herrera and Kokkinos apostrophe, harassment campaigns. I don't even... That's... Why wouldn't you just say defendants Herrera and Kokkinos? Why are you even talking about Kokkinos? Harassment campaigns against plaintiff's apostrophe was extraordinary in scope and continues to the present. Again, just rehashing the complaint. For instance, plaintiff Blum posted a U-Space-Tube video, and in response got bombarded with such terrible threats from defendants apostrophe fans. How do you know they're the defendants' fans? How do you know that? How does the court know that, more importantly? Footnote 1 is from cyberdemon.bandcamp.com, track Little Cuckold Boy, where the lyrics from each song in the album are transcribed and where the album may be purchased, which is also linked to Kokkinos' Patreon page and other social media accounts. And then there's the URL for that YouTube video, which I wouldn't watch if you paid me. Well, I might. Statement from Trevor Burt and the creation of Mad Cucks. Oh, is this the part where you massacre a statement and take it out of context like an obvious joke and try to claim it as an admission? You dork. On or about November 15th, 2017, subsequent to this lawsuit being filed and defendant Herrera and Kokkinos being served their co-conspirator and creation, defendant Trevor Burt. Dick, you and Asterios not only created Mad Cucks, you literally created Trevor Burt. He's your baby. You thought you avoided that child support, but I'm calling Burt immediately. You are toast, pal. So their co-conspirator and creation, defendant Trevor Burt, made the following statement on the Dick Show fan forum Reddit page, annexed here to is Exhibit 16, which is this statement in full, here and after Burt's statement. Oh my gosh. Defendants apostrophe Herrera and Kokkinos therefore created a character called Mad Cucks. Don't forget, they also created Trevor Burt himself. With the dust and clay of the ground breathing life into him, the benevolent gods, Dick and Asterios, created a superhuman Trevor Burt. With defendant Burt, based on an appalling caricature of plaintiff Azunian. It's an appalling caricature. I think he misspelled caricature. I don't know. I actually don't know. Is that right? Someone verify that for me, please. They can't keep getting away with it. Not anymore, now that Landau's on the case. Over the past year, defendant Mad Cucks regularly appears on Herrera and Kokkinos' podcasts and throughout their other social media platforms to promote Mad Cucks and market his content to their followers. But again, all of that money probably goes to Dick and Asterios, right? There should be some sort of agreement since they are licensing the character to their creation. Internet tab, talk about deja vu. We've heard all this. I know, buddy, I know. And it's really frustrating. But I think we're almost done. Mad Cucks always appears as a slovenly dressed, slow, dim-witted individual with a speech impediment common to people with Down syndrome. I think that's a generalization, and characteristic of a person with disabilities. Who are you to say that they're disabled? I would say differently abled persons. Right, Maddox? On or about March 7th, Herrera, as Dick Masterson, made a post on the Dick Show Reddit page advertising that the Maddox vs. Existence album was now available. Further in this post, Masterson states that Maddox vs. Existence is a perfect episode if George were self-aware of what a joke he has become. Yep, probably. Kokonos immediately responds to this post as follows: F yes, I'm buying this right the F now. I'm gonna have to mail Asterios some Dawn dish soap to gargle. Clearly, this was coordinated by Herrera and Kokonos to sell the Maddox albums to their fans. And also to buy it. As creators, they didn't need to, but they chose to anyway. In subsequent updates of this post, defendant Kokonos explains that the Maddox album Maddox vs. Existence reached number 2 on iTunes. Thanks, Paul Evans, for checking that out. At this point in time, I can't even trust my own instincts. Maybe this is Landau's game. Send him some Tide Pods. The real question is why everybody's still eating Tide Pods. I moved on to Cascade Pods a long time ago. Defamation and campaign towards Plaintiff Azunian's recent book. You can't defame a book, by the way. Bookham Dano. Should Landau have recused himself since he's clearly in Maddox's poly group and getting paid by cucking Maddox with Jane Doe? Whew. If that's the case, no, I don't think you have. Well, yes. Typically, there is an ethical rule against sexual intercourse with with someone you're representing, unless they are actually like a domestic partner or a spouse. Okay, so but that is a very good question. Defendant's apostrophe latest campaign against plaintiff's apostrophe is to destroy the book that Plaintiff Azunian just came out with on or about October 15th, 2017, entitled F*** Wales. On or about October 19th, 2017, Herrera personally and directly instructed his fans to leave negative reviews of plaintiff's new book, Wales. Defendant Herrera did this on Internet Relay Chat, a communication platform where he regularly chats and coordinates attacks with around 70 of his fans, which I just popped on for the first time today, and I'm looking forward to chatting with those guys a little more. Defendant Herrera's alias on IRC is Peen Wienerstein. Immediately following this, like, Peen Wienerstein is in a court document. This is the best timeline. Immediately following this directive, one of Herrera's fans posted the review cited in plaintiff's complaint on plaintiff's book on Amazon. Defendant Herrera tweeted this false negative review. How do you know it was false? Negative review to his other fans, and boasted about his harassment and defamation of plaintiff's book. I don't think he boasted about harassment and defamation of anything, and has continued to encourage his fans to follow suit to destroy plaintiff's book and the sales there too. No, that, if anything, Dick drawing any attention to that book has boosted its awareness and sales. Because most of us probably wouldn't even remember that Maddox was writing a book 15 years ago or whatever he announced it. Since it took him quite a long time to not actually write any new content. Defendant Herrera is the co-founder and vice president of Foundation Digital, an SEO and marketing company. SEO is short for search engine optimization, which is essentially the process of affecting the online visibility of a website or a web page in a web search engine's unpaid results. Herrera has used his knowledge and understanding of SEO and the technology, equipment, and service of Foundation Digital in the foregoing campaigns against plaintiff's apostrophe. How do you know this? And in the content and revenues generated by said campaigns, including in his podcast U-Space-Tube videos and various graphics and social media. Various graphics and social media? What is that? Okay. That's a weird semicolon. You don't usually have an and after a semicolon, typically speaking. Not in this context of usage. And in targeting his campaigns and the placement of said campaigns throughout social media and the internet, as well as inciting his fan base. Herrera is the vice president of technology and the co-founder of Defendant Foundation Digital, LLC, a search engine optimization and marketing company conducting business in New York. You just said this. With clients such as Abra, ESPN, and Disney. Defendant Greg Bozer is the president and co-founder of Foundation Digital conducting business in New York. How so? I'm pretty sure that Foundation Digital said they don't have any contacts or any business associates or any employees in New York. So how do you keep making this lie of a claim? Defendant Bozer has promoted and appeared on Herrera's podcast, The Dick Show. Citation needed. Where has Bozer appeared on The Dick Show, and where has he promoted it? Simple things to do. If it was on Facebook, just screenshot it like you did everything else and include it. Why didn't you? Plaintiffs have made a sufficient start in showing that further discovery on the issue of personal jurisdiction over these defendants is warranted. No, you haven't. All right. This is where we get into a new theory forwarded by Landau. So, Landau, some background on this. Landau apparently has requested discovery information from Dick. The problem with this is that Landau requested said discovery information after the motion to dismiss was filed, which means discovery is halted. You cannot request discovery after a motion to dismiss has been filed because you can't add factual information to the motion or cross motion or counter motion. The facts are alleged in the complaint, and the judge is required to read the facts from the complaint, not new facts that you're including in these motions against proper drafting and against the law. Not that this is a crime, it's just improper procedure. So immediately after moving defendants filed their instant motion to dismiss, here, you're defeating your own claim with that very admission. Dario Cambron, Doc should have went the full mile with Comic Sans. Yes, should have. Absolutely. So immediately after moving defendants filed their instant motion to dismiss, plaintiffs requested discovery on the personal jurisdiction issue. You had until the date that they moved for dismissal to do this, and you didn't. You didn't do it. You screwed up again. Like how do you represent people in New York other than poorly? You had a time limit to do this and you didn't do it. You could have moved immediately for it with the complaint, but you didn't do it. David Bird, I don't know if he's working pro bono or not. Oh my gosh. Plaintiffs requested discovery on the personal jurisdiction issue and fully explained to counsel for defendants why discovery on this issue is appropriate. Now that, I know Landau wrote this, but that's a Maddox line, right? He just is going to explain to him why it's appropriate. It doesn't matter if it's appropriate. It matters if it's legal, if it's warranted under the rules of civil procedure pursuant to CPLR 3211D. It's not. Defendants refused plaintiffs any discovery or information and objected to every document requested by plaintiffs apostrophe, comma, and objected to the deposition of defendant Herrera, comma, on the personal jurisdiction issue because it's barred until the summary or the motion to dismiss is adjourned. It's barred until then by the rules. You poorly researched man. And luckily, we have this document, which we will get to. As demonstrated by the numerous facts outlined above regarding defendant Herrera's business contacts to New York. Nope. You had to allege them properly in the complaint. You can't do it now. In the numerous acts he committed upon which plaintiff's apostrophe lawsuit is based, either through his company Foundation Digital, you're just making this up. You can't just make it up. You have to assert facts with particularity. Bell Telephone. I I've got to get that proper case name, but it's Bell Telephone. You have to assert facts with particularity. You can't just make a fishing statement and then pursue discovery. Your complaint has to stand on the factual allegations in it, and a fact tends to involve a date, a time, a method, a who, a when, a how. These things have to happen. Or personally through his character Dick Masterson, or with a New York resident Kokonos or New York company Weber Shandwick. Dick did not do anything with Weber Shandwick. Let's be clear about that. And I don't think that he's a co-conspirator of Kokonos at all. Hatbuckles says, and let's dispel once and for all with this fiction that Barack Obama doesn't know what he's doing. He knows exactly what he's doing. I think so. I think he was very intentional. Okay. Or against a New York company's Harry's. You can't argue on behalf of Harry's. They're not a party to this suit and you don't represent them. Or after he was served with this lawsuit and filed the instant motion to dismiss. There's no court order preventing him from doing anything at this time. You can't impute future acts to the complaint. It'd be a separate cause of action. So please, I guess, file another lawsuit. Yes, I would call Pony Cordero. I would say that Landau's conduct in his documents is gaslighting. Whatever that term actually means, I think that's what it is. Or maybe Gas should light his. Maybe he should gaslight on the documents themselves because they're only good for keeping people warm. Not only is further discovery warranted on his personal jurisdiction issue, but it appears that personal jurisdiction is fully established against Herrera and Foundation Digital. No, it does not appear that from the facts you have alleged at all in your complaint and in your affidavits, by the way, which were obviously countered in the other affidavit. You didn't assert any of this with particularity. You didn't say when Dick was doing business in New York. You didn't say how he was doing business in New York. You failed to even cite the obvious contract that might have given you jurisdiction in your complaint, only bringing it up now, probably after watching these videos. Okay. So CPLR 3211D states as follows. Should it appear from affidavit submitted in opposition to a motion made under subdivision A or B that facts essential to justify opposition may exist but cannot then be stated, the court may deny the motion, allowing the moving party to assert the objection in his responsive pleading, if any, or may order a continuance to permit further affidavits to be obtained or disclosure to be had, and may make such other order as may be just. Okay, let's look at this. Facts essential to justify may exist but cannot then be stated. No, again, you had the opportunity to state these facts earlier and you didn't. You're just trying to raise new evidence now. This doesn't work this way. Bookham Dano says, hi, I'm Heather S. and a lawyer and an activist. Please give me a list of all your clients so I can get a comment from them. It's in the mail. I'm mailing it straight to you, Heather S. from Cond Nast. In opposing, so here's his quote from a case, and I have not researched this case because, I didn't really have time to fully research this document since it took him so long to file it today. But we'll take a look and take it at face value. Dario Cambron, Jesus, Dick, just thank him for the snacks. Yeah, at this point, Dick, maybe you should consider thanking him for the snacks. In opposing a motion to dismiss pursuant to CPLR 3211A8 on the ground that discovery on the issue of personal jurisdiction is necessary, a plaintiff need not make a prima facie showing of jurisdiction, but instead must only set forth a sufficient start and show that its position is not frivolous. Wait a minute. There's something going on here that he's leaving out. 3211A. Okay. A party may move. So give me just a second. I've got to read up on this because this is bothering me. Emotion. Party may move for judgment. All right. I think I know what's going on here. Okay. So here's what they're doing. Sorry for the very unprofessional pause, but I wanted to make sure and get this right. Yes, thank you, moderator, for letting me know the section. I was just looking at it. Ashley Princess, yes, thank Maddox for his snacks apostrophe. Okay, so CPLR 3211A8 is a motion to dismiss for the court has not jurisdiction of the person of the defendant. But this is not the sole basis for the motion to dismiss, right? The sole base, the motion to dismiss primarily is based on failure to state a claim. So the question would be, in this instance, if he survives failure to state a claim, potentially the judge could order further discovery on this, on the issue of personal jurisdiction. But let's see what it says. Plaintiff need not make a prima facie showing of jurisdiction, but instead must only set forth a sufficient start and show that its position is not frivolous. But this position is frivolous. The jurisdictional issue is likely to be complex. Discovery is therefore desirable, indeed may be essential, and should quite probably lead to a more accurate judgment than one made solely on the basis of inconclusive preliminary affidavits. But the problem is that this question has been thoroughly dismantled by those affidavits and in the memorandum of law in support of the motion to dismiss. There is no allegation that is sufficient that Dick, even as a start, that Dick does any business in New York. They're just making that up. They have no particular facts. Like, they don't even have facts in their complaint leading to the conclusion that there's jurisdiction in New York. Now, raising these new issues here, they're obviously making them up out of whole cloth, and I assume that in their response that they will address this, and I'll be anxious to see what that is. Windows 95, I dropped out of my LLB, still better lawyer than Landau. I don't doubt it for a moment. In the instant case, as demonstrated by the foregoing, plaintiffs have clearly made a sufficient start in showing that further discovery on the issue of personal jurisdiction over the moving defendants is warranted. Expert Sewer, they're quoting Expert Sewer. Affidavit from plaintiff's president established that facts might exist to support exercise of personal jurisdiction over defendant in action to recover damages for injury to property. Man, I wish I knew what they said in that case, but I don't want to bore you guys while I look it up. Here, plaintiffs apostrophe have set numerous facts, including those set forth in the affidavit of George Azunian. You may be misunderstanding facts with made-up statements, which thoroughly explains defendant Herrera's substantial business contacts to New York, including being a published author under contract with Simon & Schuster, selling his book under the Dick Masterson name out of New York. Is he selling it out of New York? Was the contract actually established under New York? I don't know that any of these things are true, and they don't either. That's the best part. Through Simon & Schuster and on his own website, and the copyright of his book. By the way, his own website would be stationed in... Let's be clear about something, though. Let's be clear about something. Assuming Dick does have a contract with Simon & Schuster, and they do sell his book in New York. Simon & Schuster sells his book in New York. Dick Masterson sells his book in California. Can Landau be in any way punished for this other than loss of reputation? Madame Psychosis, yes. He can be sanctioned and have all sorts of fees and fines to the court. The other punishments would have to come from Maddox for being poorly represented, but that's pretty hard to show. And the copyright of his book and name Dick Masterson being owned by Simon & Schuster, no. That's your error of law. That's an error on your part, not a fact. And that any disputes relating to his publishing agreement and book between Dick and Simon & Schuster must be filed in a court located in New York under New York law. If that contract is still valid, if that contract is the same as Maddox's, and if there's a dispute, which we don't know that there is. Actually, we don't have any information to suggest that there ever was. On its own, the facts established in Mr. Azunian's affidavit demonstrate that facts might exist to support personal jurisdiction over defendant Herrera. No, they don't. Which entitled plaintiff's apostrophe to jurisdictional discovery under 3211D. This in conjunction with the allegations from plaintiff's complaint. Let me look at this real quick. Very unprofessional. I apologize. Bill Landau. Oh, okay. Yeah. Let's see. Evidence permitted immediate trial motion. Okay, no. Not relevant. I was just seeing if there was anything else in the statute that he failed to include, like he failed to include stuff on Maddox's statements. All right. So this in conjunction with the allegations from plaintiff's complaint, which defendants have intentionally omitted from their motion. Well, if we're talking about intentionally omitting stuff, let's talk about intentionally omitting the fact that one of your plaintiffs has a restraining order against her against the significant other of one of the defendants for stalking and harassment. Let's talk about intentionally omitting the fact that you created a video which literally defamed Dick Masterson and took out of context things. And actually, you had 4 screening ceremonies to make sure you got the maximum amount of defamation out of that video. Let's talk about those intentional omissions from your motions. Or how about intentionally omitting material statements from Maddox's statement on Reddit that show that it's clearly a joke or a piece of satire, you dirtbag. And the other facts and exhibits annexed here too. And the affidavit of Mr. Azunian, the affirmation of Mr. Landau, counsel for plaintiff's apostrophe, is more than sufficient to permit jurisdictional discovery in the case against defendants Herrera and Foundation Digital. A litany of case law throughout New York supports a conclusion and relief. See advisory SA versus Bakri Telecom. I'll have to probably do a supplemental video if I can research this stuff. I'm not going to read all of his citations. They're just boring. Here, as in Star Wars, much of the defamatory conduct, invasion of privacy, and tortious interferences actually occurred in New York or was done in conspiracy with New York parties or against New York companies. No, you don't just get to create conspiracy. You don't get to attribute the acts of Asterios to Dick Masterson. Dirtbag might be either defamation or an ableist slur. Yeah, I'm not sure if he's literally a bag of dirt or not. That's just my opinion. Can Landau be so bad at legaling that Maddox gets held in contempt? Yes, Hat Buckles. Turns out Landau has been so bad at legaling in the past that his client was not held in contempt but was sanctioned for the actions of Landau. And he narrowly avoided them. In a blistering 65-page opinion from a judge talking about all of the ways in which Landau proceeded incorrectly. And that is an upcoming video. Was done in conspiracy with New York parties or against New York companies. For instance, the Santa Cuck album was created and promoted by Kokonos in New York. Not Dick Masterson. What does Star Wars have to do with it? They're citing a case of Unigraphic Inc. versus Star Wars Corporation from 1981. That's what has to do with it. I just didn't read it because it's boring to read all of his citations. The Burt statement verifies that Herrera and Kokonos worked together for months using their respective companies' technology and equipment to character the Mad Cuck's character. What does charactering a character even mean? I'm sure that Landau is not a Mensa. Hi, I'm a building and this is how I talk. I can confirm that dirtbag is both a slur and a call to violence. Oh man, I apologize. I remember that, but not Bell Atlantic versus Twombly. Well, moderator, that's because it's in the document right here, Unigraphic Incorporated versus Star Wars Corp. I just jumped over it. Is it Bell versus Twombly? Okay, that makes sense. I always just refer to it as Twombly. Thank you for clearing that up for me. Let me help out the fans here. Herrera and Kokonos did not use technology to specially connect specially detect someone with the appropriate body size and shape and speaking methods to create the character Maddox. That is an obvious satire. And the content and attributes upon which this character and products thereto are based. No, Maddox created the content and attributes upon which Maddox are based. He did the voice. He did it. I'm going to cover previous cases by Landau from Mr. Kill Everything. Yes, that is on the menu because they're worth it. Daryl Remington, has Landau contacted you yet? Not yet. I'm kind of waiting for that letter to show up. We'll see. Drink for me being late. Clay, well, if you're late, you should take a test and go see your doctor because maybe you want to stop drinking, for the safety of the baby. This is precisely the circumstances of the instant case. Precisely the circumstances of the instant case, which the Court of Appeals envisioned in Peterson versus Spartan Industries. I highly doubt it. For instance, in Peterson, the plaintiffs, it was established that the appellant applied for several permits. That's just a typographical error. He just meant to delete that and forgot. I'll give him that one. The appellants applied for several permits and received permission to sell and store some of its products in New York. Now, mind you, what he said is that the actions of Dick are precisely the circumstances envisioned in Peterson and Spartan, which he's telling us about now. Precisely. Yes, instant case is legalese, Wild Matsu. It just means the present case that we're talking about. Where Maddox says he hopes this makes it into the lawsuit. Yes, I love how they leave that out as well. Again, that alone is probably sanctionable, and we'll have to wait for some responses, but it's very, very possible that is actionable against Landau for intentionally misrepresenting to the court, and that is offensive to anyone who's an actual ethical attorney. That is atrocious. So, again, precisely the same. For instance, in Peterson, the plaintiff, it was established that the appellant applied for several permits and received permission to sell and store some of its products in New York. I'm pretty sure Dick didn't do that, albeit some years before the alleged event alleged in the complaint. That's obviously not true. Based on this, the Court of Appeals found that the plaintiffs had made a sufficient start and shown their position not to be frivolous. Here, plaintiffs have produced significantly more evidence than that required by any of the foregoing authorities and have therefore made a sufficient start, and they're shown their position not to be frivolous. Accordingly, plaintiffs should have further opportunity to prove other contacts and activities of the moving defendants in New York as might confer jurisdiction under the long-arm statute. You sent the videos to Landau's email? Thank you. That's hilarious. Let's just be clear, I did not request that, but I do find it very funny. Okay. I've been holding off on having another drink because I don't want to get too hammered tonight. But I am pouring myself some bourbon, which I've been looking forward to for about 30 minutes. Oh my goodness. All right. They've shown their position not to be frivolous. I think that's a stretch, buddy. Accordingly, plaintiffs should have further... Yeah, okay, sorry. I already read that. Wherefore, plaintiffs respectfully request that the court deny defendant's motion to dismiss without prejudice and allow plaintiffs to conduct discovery on the personal jurisdiction issue. We'll see. All right. Okay. So this is going to be fun. New York is a single transaction state for personal jurisdiction purposes relative to corporate parties. And defendant Herrera is their co-owner. Oh, this is Foundation Digital. Okay, I misunderstood. Okay, so this is, let me start over. ASMR video. What's that? Pretend I can no longer use acronyms. Personal jurisdiction is established against Foundation Digital. Okay, so this is against Foundation Digital. New York is a single transaction state for personal jurisdiction purposes relative to corporate parties, and defendant Herrera is their co-owner and is alleged to have used their equipment and technology in conjunction with Kokonos and Weber Shandwick's equipment and technology to engage in targeted harassment campaigns against plaintiff. Even if this were true, which it is obviously not, true. Even if this were true, he would have to do it in New York. Like, he'd have to go to New York or have equipment in New York that he's using. Or he'd have to target it to New York specifically, with specificity. You can't just say that it reached New York. That's not entering the stream of commerce intentionally in New York. Read International Shoe, you dummy. Go back to law school, you dummy. Start over. When you get your license back, drive back to law school and do it. Because you didn't do it right the first time. And to create and promote their content and products using plaintiff's name. Image and likeness specifically as the Mad Cuck's character and the Santa Cuck album. CPLR 302A1 is a single act statute, and proof of one transaction in New York is sufficient to invoke jurisdiction even if the defendant never enters the state, so long as the defendant's activities in New York were purposeful and there is a substantial relationship between the transaction and the claim asserted. You haven't asserted any action that happened in New York. You can't do it because you're bad at this and because it doesn't exist. I assume if it did exist, you would probably have it because Maddox has watched everything. Here, on or about November 15th, 2017, subsequent to this lawsuit being filed, and defendant Herrera and Kokonos being served, their co-conspirator and creation, defendant Trevor Burt. Guys, Asterios, you're a dad. I'm glad to be the one to tell you. Oh, Mad Cucks, if you're listening to this, buddy, please do something like parody My Two Dads. Like that. Oh, but I'm taking half of the money you make from it. Made the following statement on the Dick Show fan forum Reddit page. Oh my gosh, he did it again! They, Herrera and Kokonos, said using an advanced algorithm provided by Dick's company and utilizing data from the place Asterios worked at, they had calculated what fan had the right body type and wit to create a parody of Maddox. The first call took several hours, but during it we laid out what would become the plan for Mad Cucks and how the people couldn't know they had worked on it too. It had to seem grassroots. As part of the deal, Dick provided me with 40 Patreon bots to fake a bigger Patreon than Maddox over the course of several months. Now everyone knows. The entire basis for jurisdiction is on your lie about a satirical joke made by Mad Cucks on Reddit after the lawsuit started, when you falsely claimed that Mad Cucks was created by Herrera and Kokonos, despite the obvious fact that Mad Cucks' video was brought to the attention of Dick by his fans. Therefore, defendants Herrera, Foundation Digital, and Kokonos created a character called Mad Cucks with defendant Burt. He's not a defendant anymore. Pretty sure you missed your 120-day window, dork. You can't do anything right. Based on the appalling caricature of Plaintiff Azunian by using the technology and equipment of Foundation Digital over the course of several months. Okay. See Taylor Devices. Proof of one transaction in New York by non-domiciliary corporate defendant is sufficient to invoke jurisdiction under New York long-arm statute, even if defendant never enters a state, so long as the defendant's activities in New York. The activities in New York were purposeful, and there's a substantial relationship between the transaction and the claim asserted. Spicy Tony stroking 3, 2, 1. Oh, man. Here, the conduct and actions stated by defendant Burt is nearly identical. The conduct and actions are nearly identical. Are. Go back to grammar school. Back before law school. Nearly identical as to what plaintiffs alleged Foundation Digital of engaging in. Oh, that's just ugly. Thanks for the support, guys. When I'm in the hospital, please visit and send flowers. Accordingly, Foundation Digital has transacted business in New York. Where? They said they have no New York clients, not one, and admittedly engaged in tortious acts against plaintiffs in New York. No, they've never admitted this. Where would you find this admission? You could cite it, but you don't, because you're bad. On its own, the Burt statement, is a joke. It's a joke. Verifies plaintiff's cause of actions for violations of civil rights law 50 to 51. No, it doesn't, because it's a joke. It's a joke. An injunctive relief. Misappropriation, unfair and deceptive trade practices, and unfair competition. Conversion of what? They didn't convert anything. And deceptive acts and misleading business practices in violation of general business law. Look at their site. Chloe versus Queen Bee of Beverly Hills. Single act of an out-of-state defendant employee shipping an item into New York, combined with his employer's extensive business activity involving New York, gave rise to personal jurisdiction. Extensive business activity in New York is the operative statement of that citation. Andrew, please send Chris flowers. That'll cheer me up in the hospital. That kid's a riot. Defendant cite to Fishberg versus Doucette, which supports personal jurisdiction in this case as to the moving defendants. In Fishberg, the defendants were located in California and the plaintiff attorney was located in New York. Sounds familiar. The Court of Appeals determined that over the course of approximately 9 months, the defendants, through numerous telephone calls, faxes, mail contacts, and emails, attempted to establish an attorney-client relationship with the plaintiff to represent them in an action in the state of Oregon. The Court of Appeals noted that it was the quality of the contacts with New York that was a primary consideration in determining whether a party transacted business within the meaning of New York's long-arm statute. Okay, the defendant in California, although never actually present, was receiving and transmitting bids over an open telephone line and was an active participant in an auction held. In an auction held in New York, an active participant in an auction. These are not analogous cases. It was directly assisted by another present in New York. Again, they have someone in New York acting on their behalf. That's agency law. Hatbuckle says Landau et al. Take a bite out of crime. Personal jurisdiction is established against defendant Herrera pursuant to CPLR 301, 302, A1 and 2. In the instant case, defendant motion to dismiss is principally based on a lack of personal jurisdiction. No, it's principally based on a failure to state a claim. It's also based on a lack of personal jurisdiction, but I'm pretty sure the longest section was failure to state a claim. Relative to defendant Herrera and defendant Foundation Digital, defendants spend over 17 pages in their memorandum rambling on about personal jurisdiction. They're not rambling. They're actually constructing a well-sourced, well-reasoned argument, unlike what you have done. Okay. Let's just appreciate the English usage of this sentence, so I'm going to start it over. How many brain cells can you count? Mr. Dogbite makes me want to study for drug tests. I can no longer count anything. All right. Oh, okay. Guys, I have to take a very important break. It'll take just a second. What kind?
Something good.
All right. I have a, you may have heard her in the background, you may not. But my wife has requested a small beverage, which I am happy to provide. I'm a benevolent head of household. Here you go. Thank you, dear.
Thank you.
Yay. All right. Okay. So, let's go back to drunk diaper changing. All right. Okay, guys. Okay. Calm down. Defendants spend over 17 pages in their memorandum rambling on about personal jurisdiction, however, failed to refer to any allegations from plaintiff's apostrophe complaint or simple facts, that render their instant motion irrelevant, and bordering on frivolous, namely, that. Whoa! Frivolous motion. You're calling their instant motion irrelevant and bordering on frivolous? The motion to dismiss for failure to state a claim and lack of personal jurisdiction and all of the legal explanation as to why is bordering on frivolous? You are alleging anything to be frivolous? You coward! Oh my gosh! Namely that A, Herrera is a published author under contract with his New York City-based publisher Simon & Schuster. You don't know that he's under contract still. None of us know the terms of that contract but Dick and Simon & Schuster. And you failed to allege this fact in your complaint. Who writes and operates under the pen name Dick Masterson. Said name and book is registered and owned by Simon & Schuster. The copyright is actually owned by Dick Masterson. Dick Masterson, the pseudonym for Dax Herrera. Learn copyright law, you idiot. At their New York location, Herrera has the same book editor as Plaintiff Azunian. It doesn't matter that you have the same editor. That doesn't matter. That actually says nothing. That says nothing about the contracts. Editors don't write contracts. Legal departments draft a contract. Okay, inside baseball. When you're at Simon & Schuster, they have, I'm guessing, inside counsel who would draft a contract, a form template contract that they would send out to every single author that they're going to deal with. That author would then hopefully, dear God, authors out there, please do this. Take that contract to an attorney whom they either hire for a lot of money or they trust implicitly, and they would take that contract and they would actually go ahead and review that contract. They would maybe line out things. They would redraft things. They would try and change terms to be more favorable to their client and not to the massive corporation. And they would actually negotiate this contract. I know Maddox doesn't understand basic business, but Landau, you should. You're an attorney. You should actually have probably done some of this stuff on behalf of a client. At some point, have you ever looked at a contract for someone, said, this is ridiculous, let me rewrite this? I do this all the freaking time. Why don't you? Take a contract, you redraft it to be more beneficial to your client, and you send it back. If you don't have an attorney who does this, you have an agent who does this. Someone does this. You cannot assert that Dick's contract is anything like Maddox's because you have no idea without actually producing it. You cannot establish personal jurisdiction for Dick based on Maddox's contract. I don't know how you can get this so wrong. Defendant Herrera and Kokonos are alleged to be co-conspirators. Alleged by you! You guys have made this up! You fabricated a thing. You don't get to base a legal decision off of your fabrication. You can't allege any facts related to this with particularity. You're just wrong. Kokonos is a New York resident. You're not arguing against Kokonos. You're arguing against Dick, who works for Weber Shandwick. You can't attribute Dick's jurisdiction to Asterios, because Dick doesn't go to New York to hang out with Asterios. Asterios goes to California to hang out with Dick. To be on Dick's show in person, he goes to California. Dick has, to anyone's knowledge, never, ever, ever done a single podcast or a single commercial activity from the state of New York. You can't just impute jurisdiction based on someone else's personal jurisdiction. One of Herrera's targeted harassment campaigns was against plaintiff Azunian's sponsor and business associate Harry's. Harry's isn't a party to the suit. You don't get to impute that against them. First of all, even if true, you don't get to do that because it's not a real thing. Harry's is not in this suit. Harry's would have to file suit against Dick for some sort of harassment campaign against Harry's. If Maddox is alleging that Dick got his contract with Harry's destroyed, he would probably have to do that under California law because all of the acts that Dick would have done would have taken place in LA, presumably, unless you can show they've taken place somewhere else. But they're not. And they're not targeted to the state of New York simply because it's a tweet to Harry's. That's not targeted activity in the state of New York. Even if it were actionable, which it's not. Subsequent to defendant Herrera being served in this matter, in filing this motion to dismiss and entering into stipulations with plaintiffs, he has persisted with his harassment campaigns. Did he promise to stop talking about anybody? No, he's done nothing wrong. Dick did nothing wrong. There you go. He's done nothing wrong. He doesn't have to make a promise unless you have a document stating that he will not make any further statements about Maddox for the course of litigation. You can't enjoin him from doing it. You can't do it, and the court hasn't done it. You just can't. You can't do any of this. Tortious and defamatory actions, these are legal conclusions. Nothing he's done has been shown to be tortious or defamatory. The only tortious act is your crime against English, and has decided to turn his vitriol and harassment against plaintiff's apostrophe counsel Kevin A. Landau and his law firm. What harassment? Has Dick called you and bothered you? Has he threatened you personally? Harassment requires an imminent fear of harm. A reasonable, imminent fear with harm, or fear of harm. It has to be reasonable to someone else, not to a dummy who doesn't understand the law like you. It has to be reasonable to a reasonable person. That's what harassment is. Seriously, this is an old common law concept. And releasing embarrassing and private information to Mr. Landau. Public documents are not private information. Your DUIs are public documents. Stop driving drunk. Your failing an interlock ignition is a public document. Public. It's not private. You have not had the cases sealed. You had the opportunity to do this. Maybe the court would reject it because it's public. You committed crimes. You're a criminal. Don't do them. That's the easiest way to not have public information about you come to light. And don't lie when you conduct your litigation. When you lie about another party, they may be interested in finding out more about you. Ever think about that? Maybe you should have. Or maybe you should have requested the court to enjoin him ahead of time. Maybe you should have told the court that you have a history of drunk driving that may come to light because of a toxic fan base or something like that. Why didn't you take these precautions in advance? Why not? Was it too hard to bike to the courthouse? It's all public, buddy. It's all public and you know it. It is embarrassing. That's the one true thing you've said in this document. It is embarrassing to have 2 DUIs, public records that you fought and lost. Because anybody can pull those documents and even, like the transcripts of your arguments from court. That can be done because they're public and the public has a right to know. And the press, which I think I'm now a member of the press officially because I'm relating newsworthy materials about celebrities via YouTube and against multi-billion-dollar corporations like Google. So I'm officially now, according to me, the press. And the press has a right to talk about these things. And if you don't want them, don't do them. And because he represents plaintiffs in this matter. No, not because he represents plaintiffs in this matter. Had you conducted yourself with a modicum of professionalism and ethics in this case, I don't think anybody would be complaining about you at all. The fact that you've poorly drafted this, the fact that you're overtly lying to the court, Those are the problems here. That's what sparked this. Your actions. And those actions aren't new to you, are they? Are they? Almeida, remember? Almeida, when you produced forged signatures, falsely produced signatures to the court? Do you remember that? Because the case law does. All right. I apologize. I have to calm down for a moment before I throw a brick through my computer monitor. And I like my computer monitor. The foregoing is more than sufficient to establish personal jurisdiction against defendant Herrera in this case. No, it absolutely is not. Because your main basis is a lie. It's a lie. What media outfit do I represent? I think the Rekieta News Network. Definitely not fake news. No, but in all seriousness, I represent Lawsplaining the Interwebs, which is a YouTube channel. Wild Matsu, and this is why Nick is number 2 on the rage board. Count Dankula, I'm coming for you, buddy. In addition to the foregoing authorities cited in the preceding section, see also Mrs. U.S. National Pageant Incorporated versus Miss U.S. Organization LLC. New York owner of trademarks related to owner's beauty pageant business alleged sufficient facts for prima facie showing a personal jurisdiction over alleged trademark infringers. There's no trademark infringement here. That case is still ongoing, and I can't wait for you to lose that one, Maddox. I'm not going to read the rest of his citations. Sorry. Defendants have waived any argument relative to service. No, they absolutely have not. The process server's affidavit of service is filed here too, and annexed as an exhibit is prima facie evidence of proper service. It absolutely is not. You failed to serve Bozer because Bozer isn't even in California. You served a UPS store manager, you dork. You didn't follow the proper procedure for service by mail. You didn't ask the court for any sort of alternative service. You failed. They didn't waive anything. The affirmation challenging service is from defendant's counsel who failed to swear to specific facts to rebut the statements. No, they absolutely did. The specific facts are, I am not in California. I'm in Nevada. You served a UPS store manager. This is not the registered service for Foundation Digital or for Bozer. Those are specific facts to rebut the statements. You idiot. Oh, you're... In the process server's affidavit, you don't just admit to service by showing up to say they didn't serve me properly. That's not an admission of proper service. You have still insufficiently served them, and you're actually beyond your 120-day window, and I really hope the court says, you know what? You can't serve them anymore. They're gone. The only person you properly served, I believe, is Dick. Because you're incompetent. You're over and over and over incompetent. Further, the parties have entered into multiple stipulations extending the time to answer plaintiff's complaint, plaintiff's apostrophe complaint, and defendant's motion to dismiss. That doesn't mean that your service was proper. You've had all this time to cure service. Why didn't you? Why didn't you just... He gave you his address in the affidavit. Why didn't you cure service then? Why didn't you contact the California Secretary of State and find the process service for Foundation Digital? Why didn't you do these basic legal steps? The window for service, Maddox, that's a great question. The window for service opened the day he filed the documents in New York. That was, let's see, I'll pull it up here in just a second for me. You guys won't see it. Filed on November 6th. So that would be December, January, February, what? November 6th. I think, has it been 120 days since January, or since November 6th? I don't even know. I think they have 120 days. Oh, it's March 6th. Okay, you still have time, Landau. Do it. Why haven't you done it? Why didn't you do it immediately? When it was brought to your attention that service was improper, why didn't you just send service? Or why didn't you get a stipulated agreement to agree to service? These are all things that can be done. Okay. None of your stipulations have included a stipulation for acceptance of service, by the way. And they should not stipulate to that. You should be forced to do it because you can't get it right until you learn to do it right. Classical conditioning, or operant conditioning, as it were. As such, no hearing was necessary to determine whether the defendants were properly served. It absolutely is, because they haven't been properly served. Further, the parties have entered into multiple stipulations extending the time to answer the plaintiff's complaint and defendant's motion to dismiss. Further, defendant Herrera is Foundation Digital's co-founder and vice president, and a copy of the summons and copy was personally served on him at his residence, which is sufficient service. No. No. When you have a foreign corporation located outside the state of New York, I believe you have to follow the California rules of jurisdiction at that point. But I don't know. He might be right on this. Upon any foreign, domestic or foreign corporation to an officer or director. What is it? CPLR 311. I'm going to look it up. I don't care if it's unprofessional. 311. Okay. Or to any other agent authorized by appointment or by law to receive service. So here's the question. The question is Dick an officer or director? Maybe he is. If that's the case, maybe Foundation Digital was properly served. Still wasn't Bozer. But actually, no. No, it's not proper, by the way, because you didn't serve Foundation Digital through Dick. You served Dick personally. You personally served Dick. To serve Foundation Digital through Dick, you would have to serve him a second set of documents in his capacity as an officer. Okay. You're so incorrect on the law that you make me question even my understanding of it. Okay, sorry. Forum non-conveniens has no application to this case. What are you talking about? It has no application to this case. Every witness is in California. Every single one except Asterios. But in this motion for Dick, Bozer, and Foundation, every witness is in California. All of them. Every single one. Maddox, Blum, they're in California as well. Heather S., who is Maddox or Blum, is also in California. Because they're lying and you're forwarding lies. Yes, Eric Blum. Maddox was served since Dick created Bozer and he served Dick. That's correct. As demonstrated above. You didn't demonstrate anything. Defendants Herrera and Coconos directed or direct numerous purposeful acts on a daily basis towards New York. No, they don't. No, posting on Reddit and Facebook and Twitter is not an action in New York. They're an action from the place the post took place. Corey Jamnick. No, there is no such thing as a case where improper forum isn't relevant. No. Oh, that's right. Bookham Dano is Heather S. That's right. Not Maddox and not Jessica Blum. Despite the fact that they what was it? They used the same font as Maddox's proprietary website font, right? Internet tab, top 10 lawsuit and competencies video win. It'd have to be like top 10, then 10 to 20, then 20 to 30, then 30 to a million. Oh, hi, Gabe. Clay wants me to say hi to Gabe and tell him he's in the Sexy Boy Club with Clay early. Gabe is a very attractive man. Good job, Gabe. Keep up the hair, buddy. As demonstrated above. Okay, yeah. Conducted a substantial amount of business here. I'm guessing you mean in New York. And clearly have sufficient minimum contacts, which weigh heavily in plaintiff's apostrophe. Oh, that's a proper apostrophe again. Favor for personal jurisdiction purposes. Yeah. And render any argument based on forum nonconveniens as frivolous. No, because forum nonconveniens has nothing to do with relevant business contacts. It has everything to do with the burden on the parties to attend a lawsuit in a forum that's not convenient because the parties and the witnesses are located in a different freaking state. They would do it in California applying New York law. That's how it would go. That's how forum nonconveniens works. Like, did you even take procedure classes in law school? Or were you in court? I don't even know. Two of the main defendants in this action, Kokonos and Weber-Shandwick, are not part of this motion. Our New York residents and both work in Manhattan. They're not part of this motion, and their actions are independent of Dick Masterson's. I don't know how this guy passed the bar. I don't know if he's ever passed a bar. It seems like he might get out of the bar or get out at the bar and then get back in his car and drive. Not sure. And both work in Manhattan. That's just my opinion, by the way. Further, defendants Herrera and Kokonos could easily defend in New York. No, defendant Kokonos could easily defend in New York. Defendant Herrera cannot. And have substantial contacts here, not Herrera. Defendant Kokonos lives and works in New York City for defendant Weber-Shandwick. Again, this is not involving Kokonos and Weber-Shandwick. I would never drink Fireball Cinnamon Whiskey. Not once. What law school did he go to? Someone, I think it's Wayne State University. Someone actually went to the same law school as him. So. All right. Further, defendant Herrera's publishing deal and copyright for his book. The copyrights are federal. Copyrights, the U.S. Copyright Office. He does not have a New York copyright. The copyright is federal. It is outside of any state jurisdiction. And the character Dick Masterson, he would trademark Dick Masterson, not copyright it. And you haven't produced any evidence that it's either trademarked or copywritten. It would be owned as a common law mark, most likely. And that would be also federal, not New York. And it probably wasn't created in New York because Dick was in California when he created the character. And are owned by his New York publisher. They're not. You're just wrong. You're just wrong because you're so dumb. Simon & Schuster, pursuant to a publishing agreement under New York law that you don't actually know if that's true. You made it up. It requires him to submit to a New York venue for any issues related thereto. No. For any disputes between Dick and Simon & Schuster. That's how choice of law provisions work in a contract. The two parties to the contract make an agreement. You have to have a party to the contract. You can't assign jurisdiction when you're not a party to that contract. Gosh, why are you so bad at everything? Further, plaintiff has an interest in litigating in the state where his and Herrera's publishing deals are based. No, he doesn't. Sure, he does if the state has jurisdiction over the defendant and where their editor and publisher are located. But their editor and publisher aren't party to this suit. You can't do that. I've said this so many times. I apologize for him being so repetitive. It's really getting frustrating. Further, defendant Kokonos uses position of Weber-Shandwick and their technology and equipment to target and harass plaintiffs and created his Patreon podcast and the Maddox character. No, he didn't. And his Santa Cuck album from a studio. No, you guys lied about that too. You created a material misrepresentation to mislead the court. I hope you get sanctioned. Oh, I hope you get disbarred. Plaintiffs apostrophe will want to personally inspect this equipment. Oh, I'm sure Weber-Shandwick's going to just let you into their office to look at the equipment. That you don't know which equipment they even used. You can't inspect it. Test it. If they used it, it obviously worked. Are you going to... Oh, this will be great. Maddox is probably wondering what algorithm they used to locate Trevor Burt to create the Mad Cucks character. That's what he wants to do. He wants to find out what equipment was used to do that so he can do it. Oh. All right. In his Santa Cuck album from a studio located at Weber Shandwick in New York, plaintiffs, tested and deposed certain employees from Weber Shandwick. Oh, that'll be rich. Moreover, Defendant Foundation Digital is a virtual company and has no brick and mortar office. It doesn't need one. It's the locus of all of the equipment. By the way, you're alleging that its servers host the podcast, right? So there may not be a brick and mortar place, but there is a locus of property owned by the LLC, and it's in California where the LLC is organized, unless you can prove it to be otherwise. I will, moderator, go through that. I'm just trying to get through this one without having a coronary. Has no brick and mortar office, and its president and co-owner, Greg Bozer, does not even live in California. Right, he doesn't. He doesn't. That's why you were incorrect in trying to serve him in the state of California. Resides in Nevada. Likewise, Patreon and Cope are located in San Francisco. This all leads, by the way, to California being the most convenient forum for everyone involved. Whereas defendant Herrera resides in Los Angeles. Therefore, with respect to the efficiency of the litigation, California and New York are equally convenient? No. Nevada is close to California. San Francisco is in California. And so is Los Angeles. New York is 3,000 miles away? 4,000 miles away? I don't even know. It's not even close to convenient. Moderator, thank you for being concerned that I'm going to die before I get to it. I'm concerned as well. I'm sure my wife is making funeral arrangements as we speak. Accordingly, dismissal on grounds of forum nonconvenience is not warranted in this case. Consumers' negligence action against New York insurer relating to identity theft and insurer's third-party action were residents of the state of Pennsylvania. Consumer was New York resident when she applied for and obtained life insurance. Yes, so the consumer and the New York insurer were both in New York when they obtained the policy. I'm not going to read these. I'll flip out. I'll flip out. And Eric Blum, I don't know if Landau knows where San Francisco is. I honestly don't. Yes, if I stroke out, you can sue Maddox for $20 million. Is it possible that Landau was a victim of a dog bite and it affected his brain somehow? I think so. The dog bit him right through the skull. In my opinion. New York is in California, you cuck. I think so. Don't Landau spell my name. Spell it appropriately, please. Okay. Plaintiff's complaint should not be dismissed pursuant to A7, applicable standard of review. This is for failure to state a cause of action. On a motion to dismiss for failure to state a cause of action pursuant to 3211A7, the sole criterion is whether the pleading states a cause of action, and if from its four corners, not from your subsequent motions, not from your If from its four corners factual allegations are discerned which taken together manifest any cause of action cognizable at law for motion for dismissal will fail. But the problem is they have to be cognizable at law. Saying Maddox is a cuck, Maddox is a cuck, Maddox is a cuck is not actionable ever because it's a joke. It's mocking. It's not harassment. It's not defamation. It's not anything. Where do I get my current day Richard Spencer haircut? Actually, I get it at a place right next to my office, Universal Cuts. My dude Adrian cuts my hair, and he is fantastic. If you're ever in Wilmer, Minnesota, go to Universal Cuts Barbershop. The dude will hook you up. Tell him I sent you. He's my buddy. Okay. When reviewing the pleadings, the court must, quote, accept the facts as alleged in the complaint as true, accord plaintiffs the benefit of every possible favorable inference, determine only whether the facts alleged fit within any cognizable legal theory. But they don't, though. That's the problem. They don't, though. because you say it's a legal theory and you have come up with something, your track record is not strong. Plaintiffs apostrophe have stated a cause of action for invasion of privacy and for injunctive relief. No, you haven't. In order to establish a claim for civil rights law, plaintiff must demonstrate that the defendant used the plaintiff's name, portrait. No. You're still misreading this. They have to use it for publicity purposes. It's an inference that the defendant or the plaintiff is endorsing the product, that using the plaintiff's image will be of commercial value for endorsement, not because you're discussing the plaintiff, which is a First Amendment protected activity and is not actionable under Section 50 or 51. It's in every single piece of case law, probably even in Leviston versus Jackson, which you cited. You liar. You're misrepresenting, again, case law to the court, and it's disgusting. Catch fire in the nicest way. Defendant's argument is incoherent. You're not one to talk about an incoherent argument. I'll get to the exhibits, Fishmonster. When I do, remind me, because I'll forget by then. I will never lose my hair like Maddox. I will not do that. Here is demonstrated above. Herrera misappropriated and used both plaintiff's name, image, and likeness in a variety of ways in New York for purposes of advertising or trade without plaintiff's written permission. Nope. Not under the statute, not under the case law. You're wrong, you're wrong, you're wrong, and you're dumb. Further, Herrera directly led or actively participated in numerous other harassment campaigns. No, he didn't. You don't have any evidence of any of this. False advertisements aren't even a real thing. At least not in the way you're using them, using plaintiff's name. You should have an apostrophe there. And websites, you can use a name. Maddox. I hope Maddox watches this stream. Maddox should be in the stream. I'm going to put Maddox's name in the description of this. I'm not appropriating or misappropriating his name. I'm just using it because I'm going to talk about it, why he's wrong, and why you're wrong. Landau, should I put your name in the stream too? And made threats. What threats? Not a single threat in the legal sense has been alleged in this action. You're just wrong. Against both plaintiff's apostrophe, which included encouraging fans to target and troll plaintiff Azunian's book. You can't target a book. A book isn't an entity that has any rights, by the way. And website, neither is a website. And to attack and threaten plaintiff Blum, they haven't attacked or threatened plaintiff Blum in any legal sense. They made fun of her. Get over it. YouTube videos are violence. I agree. What do I think Maddox will use his $20 million for? Hair plugs. He'll talk to Joe Biden and get some good hair plugs. Appalling false advertisements of her. You can't link the cuck away advertisement to Dick and Asterios because they didn't do it. Some fan did. Using her actual name, Jessica Irene Blum. And photograph without her permission or consent. Names are not protected. Public photographs are not protected. And they didn't. The tweet where you say that Dick used her image was someone else's tweet. Dick responded to it. That's not him using her image. That's someone else. I know you have problems with this. Further, Herrera actively encouraged and incited his fans to engage in the foregoing conduct against plaintiffs, apostrophe, and even offered inducements and incentives to his fans to help create said content. No, he didn't. No one was rewarded for doing any of this. Onassis versus Christian Dior. Really? Principle to be distilled from a study of the statute and of cases construing it is that all persons of whatever station in life, from the relatively unknown to the world famous, are to be secured against rapacious commercial exploitation. Commercial exploitation involves using someone as an endorser of a product. Commentary about that person is not commercial exploitation. Otherwise, the news couldn't exist. Under your standard of law. No books could exist that are true stories without a million consent pages. You can never say someone's name on Facebook. You're wrong. You're just wrong. Children's names are protected. Maybe Maddox is admitting he's a Clegg. I'm not 100% sure that children's names are always protected. They might be protected by statute, but usually that's a journalistic standard. It's probably state specific if a child's name is actually protected, and that protection is going to be limited to uses in media reporting on sensitive issues. You can actually use a child's name sometimes. I don't want to get into that. At Corey, Landau's going along with this for the money. Period. Maybe Landau's the smartest of all of us because he's just sucking Maddox's money down. I mean, think of it this way: he has to write 3 30-page motions. That's a bunch of money. Accordingly, plaintiffs may seek redress under Civil Rights Law 50 to 51 for Herrera's there's an S on Herrera's rapacious commercial exploitation, except it isn't that. And if you read the other case law in New York, you'd know why you're wrong. And leaving out that case law may be a violation of the ethics. The case law that says specifically that it's a right of publicity, not of privacy, and explains why you're wrong specifically. And if I can find it, an attorney from Minnesota, surely an attorney licensed in New York can find it too. Yes, focus, sorry. Involving a possible protected form of free speech. Oh, wait. Further, this court has repeatedly addressed that civil rights claim involving a possibly protected form of free speech or harmless humor or cruel and vicious derision as being a factual question for the jury, except not always. The instant misappropriation involves commercially exploiting plaintiff's name, image, photograph, and likeness to attract fans. Nope. And sell goods such as albums, merchandise, concert tickets. Nope. You're misunderstanding and misinterpreting what the law says and what the facts are. Whether the content at issue is meant to be funny or cruel is particularly a factual question. No, it isn't. Not in this case. In this case, these are obviously opinions. They're non-actionable statements. Whether or not they're newsworthy might be a factual question, but you have to allege statements of fact. Further, the argument that plaintiff Azunian may be a limited public figure is also of no consequence. It's of absolute consequence in the defamation claim, you dork. Public figures have different standards for defamation than everything else. In Onassis, the public figure at issue was former First Lady, and you allege defamation, so it's absolutely relevant. It may not be relevant to this claim, but it is later. Okay. Public figure at issue is a former First Lady and one of the most famous and recognized people in the world. And the court was clear that as a public figure, she has not forfeited her right to privacy and does not become a subject for commercial exploitation. That's because Christiane Dior put something that looked like the former First Lady in an advertisement to sell their product because the former First Lady was using their perfume or fashion item. I don't remember. I think it was perfume. That's a different question. A massively different question. Such reprehensible conduct is not considered in Onassis, by the way. And potentially criminal actions, they're not potentially criminal at all, alleged herein, are not newsworthy. They are newsworthy under the definitions laid out in the cases that you're omitting or entitled to any protection under New York civil rights law or the case law cited by Herrera. That's an overt misrepresentation of those cases which specifically talk about satire and comedy being protected speech under the newsworthy exception. You liar. Instead, they are precisely the type of conduct that New York civil rights law prescribes. No, they're not, and immediately enjoins. They're the opposite of it. The opposite. Again, rap musicians posting of sexually explicit videotape involving former girlfriend of his competitor in an ongoing rap war. No, that's really, really different. Plaintiffs have stated a cause of action for defamation against defendant Herrera. Not a chance. Plaintiffs set forth nearly 50 defamatory statements. First of all, they're not all from Dax. Second of all, they're not all defamatory. In fact, none of them are, which defendants simply fail to address or challenge just because they're not defamatory. And any court of any competence is going to know that. Oh, please tell me Maddox is in here. That'd be great. Ugh. Okay. Who's Maddox, man? That'd be great. Who is it? Anyway, defendant simply failed to address or challenge said statements included, but were not limited to, I think Maddox's bitch girlfriend scrambled his brains. That's an opinion statement. I think. It's an opinion. It's not actionable. States Maddox comes from an abusive family and has boundary issues. Those are opinions. And actually they're opinions forwarded by Maddox. They're forwarded by Maddox, who admits, by the way, to contaminating people's food, like his brother. Multiple statements that Maddox is dead broke. Those are opinions. We don't know. We don't know Maddox's financial situation. And saying that he's broke isn't defamatory. That his podcast is dying, that's an opinion statement too. It's not actionable. States that he was raised by gambling addicts. Opinion. Some people would say that one-time gambling is an addiction. And from the devil. Go talk to, the Amish or whatever. States that his podcast is dying and has, quote, shitty merchandise and rip-off prices. Those are obviously opinions. Unless you're saying that they're alleging that the merchandise is made out of feces. I mean, come on. States Maddox has autism. Is that an insult? Autistic people are not less than anybody else. They're just different. They operate on a different side of the social spectrum. In many ways, autistic people have significant advantages in specific fields over non-autistic people. Go watch Rain Man, the documentary about it. Is a massive failure and delusional. Those are opinions. Further, defendant Herrera created a harassment campaign. No, he didn't. To destroy plaintiff's relationship with Harry's. No, he didn't. His fans did. His fans did that. They submitted their opinion to Harry's that they didn't appreciate someone on the Madcast Media Network dropping the N-bomb. That's what they did. Harry's acted on that. And also the copping a field thing. Okay, wait, the N-bomb thing might not have been Harry's. I may be wrong on that. They may be Kendall and Hyde. I don't remember at this point. The Harry's thing was the copping a feel from the book that Maddox wrote with his name on it that he later disavowed. By stating defamatory, that's not defamatory to bring up a book that he wrote. And outrageous accusations against Azunian, such as calling him a liar who supported rape. He did lie. For one, Maddox has lied on several occasions. Calling someone a liar is an opinion. It did not say he was a dishonest business person. That's a different thing. I know that's what you're trying to link to because you've talked about it before. Okay. An attack on a person's integrity by impugning his character as dishonest or immoral may form the basis of defamation under New York law if an ordinary listener would tend to credit the statements as true. But an ordinary listener is going to look at that as a slam, as an insult, as a comedic statement or an opinion. Further, rape in the first degree is a serious felony. Supporting rape is not a crime, by the way. So saying rape is a serious felony does not matter. Saying someone supports rape doesn't matter because it's not a crime. As objectionable as it would be to support rape in the first degree, it is not a criminal act to support it. To say, you know what, rape is okay? That is not a criminal act. It's just a gross one. Statements that charge someone with a serious crime are actionable without need to establish actual harm. But you didn't charge Maddox with a serious crime. Wrong. Dax Desi says that they support rape. So there you go. Not criminal. Expect the thought police to come to your house immediately, though. Okay, so a statement that there is a cop on the take from landlord, charged landlord with a serious crime of bribery. Yeah, that's a serious crime. Supporting rape is not. Further, written charges imputing unchaste conduct to plaintiff Blum are libelous per se. Nope. Posting of pornographic pictures and statements liked to the plaintiff's name and photograph on various websites damaged her business of selling luxury handbags online, implied that she was sexually lustful and promiscuous. What, okay, so that's Lesser for, oh, wait. Cohen versus Google Inc. Or wait, no, that's from Lesser versus Panito. Yeah, posting pornographic pictures of someone without their consent probably is a big factor in that, buddy. If rape is gross, what you were doing to Landau is filthy. Oh, yeah, that's true. Cohen versus Google Inc. Statements on anonymous bloggers' blog which use the words skank, skanky, hoe, and whoring in captions describing or commenting on photographs of petitioner. Well, what's the outcome of that? Like, maybe you have a point. I don't know. You don't actually lay it out there. That's weird. Plaintiff's apostrophe is stated cause of action for misappropriation, unfair competition. No, those are actually barred because in New York, that falls under Section 50 and 51. Plaintiff has clearly stated a claim against Herrera based on bad faith misappropriation of a commercial advantage belonging to plaintiff Azunian and by explaining plaintiff's proprietary information, which of course can give rise to a cause of action for unfair competition and is preempted. Further, New York courts have found that persons have a protected property interest in their labor, skill, expenditure, name, and reputation. No. You don't get to do it that way because he's not exploiting the labor, skill, and expenditure or reputation of Maddox by listing his name. If anything, it's a cause of action under 15 and 51, which it's not. But all other common law claims to that are barred under the statute. I agree, Clay. As set forth above, Clay says I'm pretty skanky with those F me eyes. So, plaintiff stated claims for intentional infliction of emotional distress against defendant Herrera. As set forth above, Herrera had an intent to cause plaintiff's injury or recklessly disregarded a substantial probability of causing severe emotional distress. You haven't laid out a factual basis for actually sustaining severe emotional distress. You have to prove it typically. You can't just say it happened. Emotional distress has a definition. A causal connection exists between Herrera's extreme and outrageous conduct. His conduct doesn't come anywhere near the level of extreme or outrageous. Not once. Insulting people on Twitter and Facebook or wherever is not extreme or outrageous conduct in any sense because you can block them, which they do. Which they block them and have prevented them from harassing or intimidating them. You're lying about everything in this case and it's disgusting. Herrera's conduct against plaintiffs was part of an unyielding pattern of malicious behavior or conduct that will leave lasting harm upon plaintiff's apostrophe. No, it won't. Plaintiff's apostrophe suffered severe emotional distress as a result of Herrera's extreme and outrageous conduct and potentially criminal acts. If it's criminal acts, call the police. But you haven't because you're a coward and because when the police are involved, when the law actually gets involved in those alleged criminal acts, they find your side to be actually harassing people. You cuck, coward, piece of garbage. And yes, I'm stating you're a literal piece of garbage. I hope someone takes that as true. You should be thrown in a dumpster. Severe mental pain or anguish is inflicted through a deliberate and malicious campaign of harassment or intimidation. A remedy is available in the form of an action for the intentional infliction of emotional distress. Severe mental pain or anguish hasn't been established here. You don't even have a statement from a therapist stating so. Plaintiff's IED claims are premised in large part on the deliberate and malicious harassment campaigns perpetuated against him and led by Kokonos and Herrera. Doesn't work that way. Said actions and conduct was extreme and outrageous, which are issues left more appropriately to be decided by a jury. No, you don't get to just pretend things happen and then say that you need a jury to make sure that your lies hold up. Plaintiffs apostrophe have stated claim for tortious interference with the contract. No, they haven't. Don't make me do it. Don't make me go through this. Plaintiff Azunian's claim is based on a harassment campaign to destroy his relationship with Harry's by encouraging their fans to troll through plaintiff's network, looking for clips to take out of context, and in coordination with defendant's fans, that's right, spamming Harry's social media sites with defamatory. No, I'm not even going to ask. Against Azunian, including in social media posts, liar who supported rape. Harry's terminated his agreement. Not because, importantly, you laid this out in your own statement, that Harry's did not drop the contract because you're a liar who supports rape. They said the social media backlash we've been receiving is not what we're looking for, and we're going to terminate the relationship. That is not them saying that you're a liar who supports rape, according to all these people. No. The fact that they're getting negative feedback from people who were your fans, who bought Harry's products, presumably, through the biggest problem in the universe, are now saying they won't buy their products if Harry's continues to support you because of your actions. That's a completely different thing. Harry's terminated its agreement. That's not a breach of contract unless you provide the contract and show the breach. You could have done it and you didn't. And you still don't. Prior to defendant's campaign, Harry's was one of plaintiff's largest and longest sponsors. As a result, plaintiff lost nearly $7,200 in revenue per month. Lie. You're lying about that. I've never been more sure of anyone lying in my life than that statement is a lie. As such, a valid contract existed between Ozunian and Harry's. Defendants knew about this contract intentionally and properly procured the breach. You haven't shown a breach. You failed on a basic element of the breach of the legal claim, which resulted in substantial real damages to plaintiff Ozunian. Foregoing states a cause for tortious interference with the contract. No, it doesn't, because you failed to allege the breach. And you failed to link the breach, which hasn't occurred, to a cause, causally to the actions of the defendant. Not going to read your citation. Further, plaintiffs can recover for tortious interference with the business relationship if they can prove that the defendant tortuously. So I guess you grab someone and start stabbing them and carving off their skin, with a continuing business or other customary relationship not amounting to a formal contract. What continuing business relationship or customary relationship are you talking about? The standard encompasses a considerably wider range of conduct than that contemplated by Herrera. Here, Herrera used fraud, misrepresentation, economic pressure, and tortuously interfering with plaintiffs of Ozunian's business relationships. Which business relations? They have to be stated with particularity. You can't just make vague accusations, and fans are not fans of a free podcast are not business relations, and you don't have those business relations with them. A business relation that they're contemplating here would be like some sort of semi-formal arrangement that just isn't memorialized by a contract. No, Bookham Dano, they have never produced a Harry's contract. They've never talked about the terms of it. They've never produced any evidence of a drop in income or anything like that. They've just said they lost up to $7,200 in the complaint. Up to, based on the number of clicks that they might be receiving, they lost up to $7,200. And then now they're just running with the lie and trying to substantiate it based on their own lies. It's ridiculous. It's offensively bad. Plaintiffs have stated a claim for conversion. No, they haven't. There's no property being converted. Has addressed the issue raised by plaintiff's apostrophe instant. Oh, wait, that's proper. Plaintiff's instant conversion claim, and held that electronic records that were stored on a computer and were indistinguishable from printed document is subject to a claim of conversion, except they have to use them to the exclusion of your ability to use them. They would have to remove them from you and use them. If any of this were true, they didn't do that. Defendant infringed on plaintiff's intangible property right to a musical performance by misappropriating a master recording, a tangible item of property capable of being physically taken. A master recording. Computerized client investor list was convertible property, but conversion requires use to the exclusion of the owner. I don't know why Maddox hates tortoises. Plaintiffs stated claims for... There's supposed to be an apostrophe there! Plaintiffs stated claim for false advertising and deceptive and misleading business practices. Oh, wait, I guess not. Because, if there is an apostrophe there, the sentence is incomplete. If there's not an apostrophe there, I guess it's a complete sentence. We're just talking about the plaintiffs... That the plaintiffs did state claims. Plaintiffs stated. So not the plaintiff's possession of stated claims. The plaintiff stated claims. Okay. Man, this is getting tough. Here, Herrera bought multiple targeted false advertising campaigns on Reddit and Facebook targeting plaintiff Ozunian. This is not illegal. It's not illegal to advertise, even to their fans, even to him. Dick could try and get George as a fan, as a podcast subscriber. He can do that. George has an easy way to avoid that advertisement. It's get off of Facebook. Suggesting that plaintiff Ozunian's fans should unsubscribe from his podcast. Yes, they should. They should do that. Unsubscribe from Biggest Debate immediately. It's garbage. This satisfies a consumer-oriented element. No, it doesn't. Suddenly we switch to like bold. Further, defendants use similar harassment campaigns and defendants apostrophe use similar harassment campaigns and trolling against consumers. Plaintiff Azunian sponsors Herrera and Coconuts created said false advertising campaigns, as well as the Santa Cuck album and the Mad Cuck's character. No, they didn't. Largely from Weber Shandwick's offices. No, they didn't. Where Coconuts works in Manhattan, which the Burt statement verifies. No, they didn't. And no, it doesn't. It's a joke. And describes in detail through jokes. Therefore, defendants' actions towards plaintiff's apostrophe occurred within the state of New York. No. Or materially deceptive and misleading. The only materially deceptive and misleading things are your statements. I'm done with this document. Let's quickly burn through the affidavit and the exhibits. I'm about to die. George, being duly sworn, deposes, says the following under penalties of perjury. I'm a plaintiff in the above entitled action. I'm familiar with all the facts. He's familiar with all of the facts. He's lying under oath. I make this affidavit on personal knowledge, and all documents annexed hereto are true copies of the original documents. On or about November 6th, the complaint was filed. I've read the attached complaint. Jacob Cerizia, how does one become a Rekieta News Network reporter? You got to talk to my agent for that, Uncle Buck, I believe. Or possibly submit your query to Here's What I Don't Get. They are in charge of recruitment. I'm an author. Why doesn't he just... Notice, guys, he stopped saying I'm a writer because we laughed at him too much. Operating and conducting business in New York under the pen name Maddox with a publishing contract with Simon & Schuster. My first book, entitled The Alphabet of Manliness, was published by Citadel Press Books and the Kensington Publishing Corporation under the pen name and copyright Maddox. Do they own that copyright, Maddox? Because that's what you're saying about Simon & Schuster owning Dick's name, you idiot. I hope they own your name. I hope someone else owns your name. This book reached number 2 on the New York Times bestseller list. My most recent book is entitled Fast Risk Whales and was published in October 2017 by Simon & Schuster under the pen name Maddox. My editor, Jeremy Ruby Strauss, is a poor man for having to read it. Is employed by Simon & Schuster in New York and is based out of their New York office. Defendant Dax Herrera is a published author operating and conducting business in New York under Dick Masterson with a publishing contract with Simon & Schuster. Character created by Dick Masterson, which his book and Patreon podcast, Men Are Better Than Women and The Dick Show, respectively, are based on, which uses generated the revenue on Patreon, was Upon Information and Belief, created in New York City. Wrong. You made that up. Not on information and belief, based on false lies designed specifically to mislead the court into finding jurisdiction proper, you lying cuck. Gats, in my opinion, would it be funny if all of my fans started faxing Landau pages full of apostrophes? Man, I don't know. That's a lot of faxing. I do not support the act of faxing. I think it should be a criminal act. And the copyright is name and own was transferred by contractual agreement to his New York City publisher. Nope, doesn't work that way. Oh, you liar. Defendant Herrera operates under the name Dick Masterson. How? How does he do that if Simon & Schuster owns it? You idiot. You can't... So he's paying a royalty every time he does his show to Simon & Schuster? Really? You think so? Was that taken in your accounting? Did the biggest problem pay royalties to Simon & Schuster, who owned the Dick Masterson character that was on the show? Did you license Dick Masterson from Simon & Schuster, who owns it? The copyright of his book is in Dick Masterson's name. Yeah, because that's how you copyright under a pseudonym, you dork. Dumb. The authorship on application Men Are Better Than Women is Dick Masterson. It's a pseudonymous authorship. You can look it up on the copyright.gov website on how to do it. It's in the help section. This doesn't even require a law degree. People do this all the time. Normal, non-lawyer people do it all the time. The majority, if not all, communications, representations, and statements made about me on Herrera's podcast are in the name of Dick Masterson, not Dax Herrera. Dick Masterson, literally Dick Masterson is in California because it's owned by Dax. Dick Masterson has his own website for his book. Yes. His book can be purchased through him or Simon & Schuster. Shockingly. I have annexed relevant pages from my publishing contract, which are stupid and wrongly annexed. Cats, I already answered this. Okay, in my opinion, it would be funny, but I do not endorse sending pages of apostrophes to Landau by fax. It would be funny, but don't do that on my behalf. Certainly not. That would be that would be beyond proper lawyerly conduct. Herrera solicits money and operates under the Dick Masterson name on his Patreon page for his podcast to hundreds of New York residents. Prove it. You can't even prove it. Which pay him substantial sums of money on a recurring monthly basis. Based on my information and belief and reported by the platform, Dick Masterson podcast makes over $22,085 per month. What does yours make, Maddox? 1/100th of that? 1,000th? No, 100th. 100th of that. Oh, wow. Dick, congrats being 100 times more successful than Maddox. Would it be funny if Landau was served papers full of apostrophes? Oh my gosh. Mr. Herrera's editor with Simon & Schuster is also Mr. Ruby Strauss, who he contacted by email immediately after being served with a lawsuit in this matter on or about November 14th. He CC'd me to this communication, which is annexed here to as Exhibit 6. Subsequent to the instant lawsuit being filed, he's continued his harassment campaigns against me and Ms. Blum and continues to target us, post defamatory racist. These are lies. He does not post racist or misogynistic or hateful content throughout social media about you and Ms. Blum. He really doesn't. That's an overt lie. Maybe his fans do, but he doesn't. And you haven't attributed any of the statements to him. All right. Okay. So I'm going to skip most of these exhibits because these exhibits are all in the lawsuit. Oh, what a dummy. All these exhibits are in the complaint. These Reddit posts. Go download these documents and read them. If for nothing else, because half of the things are really funny. Landau tries to sue me for bringing all this negative press to his business. It'll obviously fail, but are you going to represent yourself? Brian will cross that bridge when we get there. Exhibit 17. I'm getting reports for Exhibit 17. So here's 13, 14, 15, 16, and 17. Okay. I'll read this real quick. Maddox versus Existence available now. For real this time. Deep discounts. So this is posted by Maddox. Maddox quote in 17 is attributed to Dick. For real this time. Deep discounts. $1.99 for the first bonus episode of Bestest Debates in the Universes. A show that doesn't yet exist. Based on a one-sentence synopsis from a Reddit comment referring to George's own bonus episode. Maddox versus Existence is a perfect episode if George were self-aware of what a joke he has become. Available now on iTunes, Google Play, Amazon, needs price adjustment, and Groove Music. Just search for Maddox. Yes, this is clearly posted by Maddox. Like, clearly. There's no way that this was made by Dick. It's posted by Maddox. Then here's Asterios' response. F yes, I'm buying this right to F now. Some updates. Wow. Good job. Here's Exhibit 18. And let's go through the... Yeah, they're... Maddox, they are misappropriating your quote to Dick Masterson. Looks like Dick's got another $20 million lawsuit coming. Right, buddy? Yes. Sue them for defamation. Okay. How much do we have to donate for you to visit Landau in person and hand him a basic grade school grammar test? I should make that like a $1,000 Patreon goal. That'd be hilarious. Okay. So this document is a little weird. Just read the openers, moderator. Thank you. The rest is redundant. Okay, I'll just read the headers. We'll wrap this stream up pretty quick here because it's getting really long. All right. So this document, just to be clear, this document is from Dick. This is refusing the discovery requests from Maddox. Okay, so this document was authored by Sarah Matz. So the general objection, they have these general objections. I'm going to summarize and paraphrase this. The general objections apply to everything. So I'll read through these general objections real quick. And then they apply to all of the statements which have some specific objections listed. So I'm not going to go through this document line by line because we're at 2 hours and 40 minutes. So Herrera generally objects to the request to the extent that they seek, either directly or indirectly, information and or documents that are privileged by reason of the attorney-client privilege, work product doctrine, or any other applicable privileges or protections, or otherwise immune from discovery. Someday, guys, I will do a federal rules of evidence video and talk about these things. But basically, any communications directly between an attorney and a client in contemplation of a lawsuit, even an upcoming lawsuit, are protected. Work product doctrine is anything that you would produce in the course of business in contemplation of an upcoming lawsuit that is privileged. And then, any other applicable privileges or protections are otherwise immune from discovery. That's just kind of a catch-all phrase. Yes, 3214 is relevant here, and I will talk about it when we get to that part. Herrera generally objects to the request to the extent that they seek, either directly or indirectly, trade secrets, proprietary information, or confidential information. Many of these requests do. Herrera generally objects to the request to the extent that they seek information and or documents not within the possession, custody, or control of Herrera. If he doesn't have them, he can't produce them, obviously. Yes, and the best form for that would be Milo's pro se case. Thank you, moderator. I was just about to go back to that. This trade secrets or proprietary information, those can't just be released because Maddox, in theory, could take proprietary information. Like, for example, he asks for the names and identifications of all Dick Masterson's Patreon supporters. So, and presumably he would then want to contact them or use them in a targeted advertisement campaign, right? Those are potentially protected documents because they're not publicly available. Herrera generally objects to the request to the extent they seek information and or documents that require plaintiff to conduct investigations, acquire information not presently within Herrera's possession, or requires Herrera to compile or evaluate information in a manner which is unduly burdensome, oppressive, or harassing. Don't make me do a bunch of work for your own problems. That's what they're saying there. Herrera generally objects to the request to the extent they seek information and or documents that plaintiffs already possess, or that is equally available to plaintiffs as it is to Herrera. This is public documents, Facebook, Twitter, stuff like that, or stuff owned by other people. Herrera generally objects to the request to the extent they purport to impose duties and obligations which exceed or are different from those imposed by CPLR. He objects to requests to the extent they subject Herrera to hardship, undue burden, oppression, or embarrassment. They objects to the requests that they attempt to incorporate definitions of or rules of constructions beyond the scope of what is permissible. Objects to the request to the extent that they call for the production of documents and or information that are irrelevant, immaterial, or not reasonably calculated. And you'll notice that when we get into these, we're almost there, but when we get into these, they're all overbroad. Objects to the extent they are vague, ambiguous, insufficiently specific, overbroad, unintelligible, use undefined terms, capable of more than one interpretation, or require Herrera to speculate as to meaning or scope. You've got to be specific in all of this stuff. Herrera generally objects to the request to the extent they seek documents from Herrera without any restraints as to the period of time. You have to put a reasonable time limit on all of this stuff. So request number 1, documents. So these are the requests. So the requests are from Landau. The responses are Matz's response to them. All documents reflecting or concerning Dax Herrera's business pursuits and interests related to the Dick Show podcast on Patreon, including but not limited to any financial and accounting records related to his Patreon account, not necessary. Gross profits, not necessary. All subscribers and patrons of the show, not necessary, and any payments or compensation or other benefit made to an employee or independent contractor or contributor to the show. So this first thing is Herrera objects to this request as discovery is automatically stayed pursuant to CPLR 3214B while a motion under 3211 is pending. So until there's a court order, yeah, I got you, Tess. The response is being redundant. I'm gonna just cover this thing. So until there's a court order stating that he has to do discovery, discovery is automatically stayed. So Dick hasn't violated any rules by refusing this discovery. This discovery request was filed after. It was filed after the motion to dismiss was. Adam Smith, if the stars align, you could ever come to LA, for what movie would you most like to do a dictation? Oh man, that's a good question. Probably Starship Troopers, which is one of my favorite movies of all time. Hat Buckles, spoiler alert. After losing in court, Maddox's career rebounds when his book, My LoLsuit, a collection of his legal filings, is a comedic bestseller. This is actually the most likely outcome of all of this. Okay, so yeah, these responses are redundant to these requests, these general responses. They're not properly limited. So the request number 2, all documents reflecting any checks, wire transfers, or other payments made by Dax Herrera to Asterios Kokonos from January 2015 to the present. Okay. I guess what they're trying to do there is establish a business contact by him sending money to Asterios. But it's, probably not stated with specificity. All documents reflecting any communications or agreements exchanged between Dax Herrera and Simon & Schuster or other New York-based publisher of the book entitled Men Are Better Than Women, including and any and all communications and documents exchanged between Herrera and Jeremy Ruby Strauss. This is well beyond the scope of discovery. My Cousin Vinny's a good flick, but man, Starship Troopers just has too much comedy in it. Request number 4, all documents reflecting any communications or agreements exchanged between Dax Herrera and Simon & Schuster or other New York-based publisher or label of other book, short story, music, or other such media. Again, overly broad, way too broad in scope. You can't do this. Any documents related to the book and website Men Are Better Than Women. Any and all documents related to Men Are Better Than Women, that would include all of the stuff. Including but not limited to any and all agreements, publishing information, copyrights, trademarks, book tours, appearances, gross sales, visitors, followers, social media where it is currently sold, merchandise, and all communications. This is, again, overbroad and way outside of the scope of this. Men Are Better Than Women was published 10 years ago and would not have any relation to the arguments put forward for any of these campaigns. Simon & Schuster is not a named party in any of these things. Again, way overbroad in scope. All documents reflecting any and all past and present clients or customers of Foundation Digital, including any and all agreements. No, obviously not. Obviously, this is protected trade secrets. There's no way you could do this. Any and all agreements, invoices, and communications exchanged between Dax Herrera and Greg Bozer, any past or present client or customer. No, they're not going to release this information. Not a chance. All documents reflecting any projects that Dax Herrera has sold to Fox or Spike TV. Maddox would have all of this stuff. He was a co-partner in this, which he neglects to mention in his trademark suit. All documents, agreements, and communications exchanged between Herrera and Spike TV or Fox. Doesn't have to do those. Those are way outside of the scope of this, by the way. Dax Herrera's personal tax returns from 2007 to present. Yeah, right. Why would he dare do that? All documents. I know that the theory is they want his New York tax returns, which he doesn't have because he's not paid in New York. Or I'm guessing he doesn't have. I don't actually know that. All documents reflecting any real property owned or leased by Herrera. Any real property owned or leased by Herrera for 2007 to the present? No. First of all, that'd be publicly available information. Go find it. You go down to the county recorder's office and find it, you coward. Foundation Digital tax returns for 2007 to the present, not a chance. All documents reflecting any communications exchanged between Herrera and any owner, officer, director of Foundation Digital, including... to do this, you'd have to narrow the scope to documents relating to... so it says related to the Dick Show, plaintiffs, or the allegations from plaintiff's complaint. No, I don't... that might be okay, except it's time barred, but it is still kind of ambiguous, and you don't know that any of these communications have occurred. All documents reflecting the past and present location of Foundation Digital servers, equipment, and technology, and the documents and information stored on said servers. These are phishing. Like all of these are phishing. They didn't allege with particularity that any of these things have happened. They just said some things and now are trying to request this data. All documents reflecting the past and present location of the servers, equipment, technology that the Dick Show is hosted and stored on, and the documents and information stored on said servers. Nope. You made it overbroad at this last statement here. Documents and information stored on said servers? No way. That's going to be protected business information, proprietary information. You can't do that. So then here's just the certification of the insufficient service on Bozer. All right, guys. That's the documents. We're almost to 3 hours. So I'm going to have a couple minutes. If you have any questions, drop them now. Much to my heart's chagrin. If you've got anything, drop it in the next couple minutes. I'm going to end the stream very soon because it is late and this has been long and wonderful, but we can't keep going forever. So let's see. We're at 2 hours, 52 minutes, and I'm going to leave like 2 minutes. At Jamie Hughes, Maddox really does believe that he owns people. I'm pretty sure that's true. When are my videos on being an Article 4 free inhabitant happening? Dax, Desi, they're happening soon. I'm actually going to live stream, watch some sovereign citizen videos and comment on them and comment on the Fourth Amendment questions involved in them. That should be fun. Would it be illegal for me to deliver thousands of random documents to him marked discovery all documents for Maddox? I don't think it'd be illegal, actually, at all. But you'd want to check with a lawyer in your state. What do you think will become with Heather at this point? Heather is obviously not the real Heather. I think that may come to light to the court, and that would be interesting. If this goes past the motions, you can bet discovery is going to come about who Heather is. Is circumcision moral? I think so, but other people may disagree, and that's okay. How long until a judge finally gets this in his hands and laughs at it? I think we should see a ruling on these documents probably within the next, I hate to say it, but probably 45 to 50 days on that. We'll know what the disposition of the case is at that point. Is it illegal to shit on the bus? Probably. Next steps for this lawsuit are for LoLsuit are for Asterios is going to respond on Thursday. We'll be doing another live stream on Thursday. It'll be slightly later than this one, but I'll still try and do it as early as I can. So Asterios will have to respond. Dick will have to respond. Landau has to respond to Weber Shandwick and Patreon still, and then they will respond back to him, and then judges will be ruling on all this stuff. When does Landau get to put up or shut up point? Lots of lying and implying still. It'll probably be put up or shut up now. Like, he's already there, and unless this judge finds any merit to this, this should be ended with dismissals. Gonna have to delete this video because you said Jamie Ruby Strauss's name. There you go. Is this a question? Yes, that's a question. How worried, confident do you think Maddox is about the lawsuit? I think Maddox is probably overly confident. I'm being sued by Matlock, Atticus Finch, and the ghost of Cicero. Do you have Lionel Hutz or Kevin Landau represent you? Lionel Hutz, 100%. Sorry, Bookham Dano. I keep forgetting that you're Heather S. I hope your deposition will be really interesting. Would it be funny then? Yes, it would be funny. What's the worst case scenario for Maddox and Landau from the Dick Show? Worst case scenario is sanctions, and those sanctions would be monetary sanctions, attorney's fees potentially, which as you probably know are going to be massive, and then potentially the worst case scenario for Landau would be that the court finds that he's intentionally misleading and misrepresenting them, and he gets disciplined by the ethics committee. And the worst case, even further than that for Landau, would be that Maddox sues Landau for his incompetence. My life is complete. I did address you personally several times tonight. Can Maddox handle the truth? He can't handle the truth. With his all when he then turned the gun on himself. It's actually like no joke that is possible. Where does an opinion become actionable? In my opinion, Maddox is a murderer, thief, con artist. Is that libelous? Really, really good question. And it's a really good question. It's probably not actionable. Unless you have to really like persist in the point of saying that to where Maddox's name becomes associated with one of those things. Probably. Is this the first case where a legal retainer involves the counsel informing the client, who's a good boy? You're a good boy, aren't you? You're such a good boy. Yes. The Dick Show asked, what's the worst case scenario? Oh, I just covered that. What can the average person do to hold Landau accountable for his behavior on this case? I don't know. It's probably really up to Maddox to hold Maddox or the defendant's attorneys to hold Landau accountable for his behavior on this case. If the defendant's attorneys find it reasonable, they could file for sanctions against him. They could charge him with materially misrepresenting to the court. It's happened before to Landau. Again, that's going to be an upcoming video. He avoided sanctions in that case. Not sure he'd avoid them in this case or not. Clay, I'd drink with you, but I'm out aside from this drop. And I'm not going to pour anymore because it's getting late. Mad Cucks, I would love to represent you in a dual paternity lawsuit. That sounds great. All right, guys. 2 hours, 57 minutes. I think we're going to shut it down. I'm going to let the stream close out for just a minute because, you know, I'm going to see if I can watch me catch up to me waving goodbye. And once I wave goodbye, once that buffers out, I'm going to end the stream. Thanks, guys. Really enjoyed it. Really appreciate you guys hanging around. Lots of fun. Join me Thursday, and we'll see what happens. Peace.